welcome everybody along to this Planning Applications Committee meeting, Thursday, 23rd of March, 10:30. Could I just remind everyone to make sure their mobile phones are switched off, and this meeting may be recorded and subsequently made available to the public for listening purposes. Lucy, could you confirm the Sederunt, please?
Good morning, everyone. We have 14 members present. We are quorate, and so far I have received 5 apologies from Councillor Blake, Councillor Diggle, Councillor Gilroy, Councillor Groom and Councillor McGregor. Councillor Witts and Councillor Ferguson are not present but may be along later in the meeting.
Thank you, Lucy. Any declaration? Sorry.
Yeah,
Stephen.
So, apologies. Could I please submit apologies for Councillor Ferguson and Witts?
Noted, thanks.
Have we got any declarations of interest? Ivor.
Chair, item 5, one of the objectors is a far-out relation of my wife, but I don't think that the relationship is close enough that it would affect my judgment on this application.
Thank you, Ivor. Jane?
I have a familial connection to 2 of the objectors on item number 5 and a financial interest in a property adjoining the application site.
And I will have an interest on item 7, as I've said, some of the objectors are my relatives. So I will be leaving the chair and leaving the meeting. No one else? Right. Thank you. Lucy, could you outline the procedures to be followed, please?
The Planning Applications Committee will consider each application in turn as detailed on the agenda. The case officer or other appointed officer will make a short presentation addressing the determining issues accompanied by digital images. Any late information, amendments or corrections will be reported at this time. Members may ask questions of officers following the presentation on points of clarification. The chairman has been provided with a list of eligible representatives who have registered to speak at this meeting within the period specified in council policy. No other persons will be allowed to speak. The chairman will individually invite those who have registered in advance to speak to make their representation, after which they may be questioned by committee members. No questions may be asked of members. The order of eligible parties being heard will be as follows: third parties objecting to an application, third parties supporting an application, statutory consultees objecting to an application, elected members of Dumfries and Galloway Council who are not members of the Planning Applications Committee. Such members should withdraw from the committee chamber after making their presentation, applicants or their agents. Representatives have been placed in alphabetical order, and a copy of the public speaking list is available from the committee officer taking notes of our proceedings. Presentations will be strictly limited to 3 minutes per person, excepting for national and major developments, which by their very nature are more complex, where the time limit will be 5 minutes. The chairman of the committee will ask you to come to a conclusion if you take too long. Representatives are encouraged to use the time allotted to clarify any points they consider material and address the determining issues. Certain matters are not normally material planning considerations and will not be taken into account by the council when deciding on a planning application. Representatives should not raise any new matters without explaining why they were not raised earlier with the case officer. Please do not repeat what is in the report, as members will have already read the report. After all the representations have been heard, the meeting is then in formal session, and no members of the public may address the committee from the public gallery. The Planning Applications Committee will then proceed to determine the application, or, where appropriate, agree a recommendation to be made to full council, who will determine the application.
Thank you, Lucy. Item 4 on the agenda, Chapelhill Farm, Waterbeck, plan application, erection of dwelling house and installation of a septic tank and Soakaway, 16/1751/FUL. And this is a deferred item for the last meeting, so go. Oh, sorry. No, could I? Sorry about this. Could we confirm the minute of the previous meeting? Right, thanks. As I say, item 4, it's deferred for the last meeting. So I'll ask Lucy to read out all those who are eligible to take part in.
The members who are eligible to take part are Councillor Martin, Councillor Dempster, Councillor Brake, who is not present, Councillor Ian Crothers, Councillor Dick, Councillor Dryborough, Councillor Ferguson, Councillor Geddes, both who are not present. He's here. Councillor Gilroy, who is not present, Councillor Hislop, Councillor McGregor, who is not present, Councillor Maitland, Councillor McCaughtrey, Councillor McComb, Councillor McKee, Councillor Syme, Councillor Thompson, and Councillor Witts, who is not present.
And we've got Lindsay. We've got Lindsay speaking this one. If you just give us a quick recap, Lindsay.
Thank you, Chair. I'll just quickly run through the slides just to refresh everyone's memory. This is a location plan showing Chapelhill Farm, which is located approximately 3.7 kilometres east of Waterbeck. And Waterbeck is located approximately halfway up the slide on the left-hand side. This first photograph has been taken from the public road on the approach to the site from the west, and the application site is situated in the corner of an agricultural field adjacent to the C63A public road and the farm access track, and it's approximately 1.1 kilometres from Chapelhill farmsteading. Moving to a position just east of the farm access, this photo looks back in a westerly direction across the application site. This photograph is taken from the farm access track looking back across the application site. And this photograph is taken travelling further along the farm access track towards the farmsteading. It shows it within its landscape setting. Moving into the farmsteading, you can see that it's a range of modern buildings which are located to the right-hand side. And then to the left-hand side of the steading is the farmhouse and a range of stone-built traditional steading buildings. This is a long-distance view of the farmhouse and the steading within its landscape setting. And this final photograph is a long-range view which shows the location of the application site in relation to the farmsteading.
Thank you.
Sorry?
Didn't know he finished.
No, there's still the slides to go. These two plans show the location of the application site in relation to the farmsteading and the farm holding. The farmsteading is located towards the northern end of the holding, whereas the application site is on the southern edge of the farm, overlooking the public road and land out with the control of the applicant. The area shaded green on the farm holding plan, which is in the left-hand corner of the slide, shows the area of land which is subject to possible sale and excluded from the labour requirement. This is the proposed site plan, which shows the dwelling. It's orientated to face south over the public road, and access would be taken from the farm access road with an integral garage to the rear. These are the proposed elevations, and finally, this is the proposed floor plan. The application is recommended for refusal for the reasons set out in the report.
Thank you, Lindsay. Members in session. Archie.
Thanks very much, Chair, and I was glad I went on the site visit. I think going on the site visit showed you the actual distance between the start of the road right to the farm itself. And when you look at the report, it says quite clearly that favourable consideration will be afforded to those proposals where the applicant is able to demonstrate. And there's a few bullet points. A new house is essential for the proper function of the farm, rural business, and there is a clearly established need for a worker to be readily available. The need relates to a full-time farm worker or one who is mainly involved. Now, there is no appropriate available alternative accommodation. We already know that the applicant's son has been asked to leave his house so that it can be sold on. The need for a house is not a direct consequence of the recent severance of the house, so that's fine. But when you look at the situation up there, and just yesterday in area committee, we had a police report looking at the A74 and how travelling criminals actually hit Annandale and Eskdale in a very hard way, especially on the A74 corridor. And Eaglesfield is not far away from the farm itself. The rural crimes that are actually happening there, I see that there potentially is a need for a house in this area. So I would be prepared to say that we do grant as an exception to policy for those reasons that I just said. When you look at the economic viability of actually putting something into the farmsteading itself, the actual costs are massive to get the services actually into that particular farm. I think it relates well to the other three properties that are actually on that part of the road. So therefore I would suggest that we actually approve this application for the reasons stated, Chair.
Chair, could I just ask Councillor Driver, would that be subject to the normal things that you would expect, such as a Section 75 planning obligation to tie it to the land, occupancy condition, and any other standard conditions?
David, Ian?
Thanks, Chair. Thanks very much, and thanks very much for the committee. As like Archie, I thought that for allowing the site visit, I thought it was important we go at that, and I actually think that presentation today made it clearer as well. It's slightly amended to the previous one, but and as far as I would agree with Archie that this is an application that I could certainly support. We've got I can hear something in the background. Sorry, Chairman. We've got a Labour report contained within it's not actually within the report, but it's part of the appendices on the website. There's justification there for this residential unit. I think Archie's already said. I think that the topography of the land doesn't lend itself well at all to a traditional build, and therefore there would be excessive costs against that if we built up near the farm, that is, rather than the actual proposed site. The existing traditional buildings as well, it was obvious when you're on the site visit, I felt that they were material, to say the least, to the operational functions of the farm itself, and to actually remove one of them and try and convert it, not only would it be difficult, but it would disrupt the operational function of the farm, and ultimately it'd have to be replaced with a portal type shed, or it would create another site somewhere else, just making it quite difficult. The servicing of the site, we've got a couple of attachments again on the website. It's demonstrated clearly that to service the site at the farm is materially more expensive than what it is at the road end. I think there's something, a quote for, I think it's £8,000 for electricity, I think it is at the road end, and £32,000 at the farm from Scottish Power and Energy Networks, and a local contractor has put in a bid and says how much more it would be. I think it's around about £8,000 from memory for the water connection to the public water supply. Ultimately, it'd be probably, I think it's in about £1,000 probably at the road end. So these are material considerations, I think. And also, it's mentioned previously, I think, and Archie's touched on it as well, but there is, if we allow this residential unit to be built out on the proposed site, there's, for security reasons, there's certainly benefit there. And I would say for those reasons, as Archie's clearly outlined, that I would certainly second Archie if he's moving it as a motion to move to approve this application for the reasons outlined, subject to conditions as Mr. City's already talked about.
Ian? David?
Aye, thanks, Chair. I'm kind of concerned about some of the issues that the councillors just raised about the provision of electricity and water and all that sort of thing. Surely that's not a planning consideration. And the other concerns I've got is that the application has been up twice before and has been refused. It's up again, and the farm size has actually reduced in that time, albeit they can't get a date as to when it happened. But these things have happened, and I don't think that certainly increases the need for a house on the site. And I think closer to the farm might be more beneficial, and we get the electricity supply a wee bit cheaper as well. So I would certainly move that we agree the recommendations as submitted by the officer.
Iowa?
Chair, it concerns me, this report, that if you take 4.7, where you've been asked to provide a business plan, and when you've got a business plan that demonstrates that you do need 2.08 labour units, it's not worth the paper it's written on because it's only relevant to one business. Well, this is agriculture. One farmer may move in and say he's got to do one thing. One farmer says he may do another. To make that statement, I would say that suggests that it doesn't matter what comes in here, we will not take it into consideration, and any planning application for a house in the countryside under an agricultural requirement would be refused because no business wouldn't put that disclaimer on it. So I've got concerns about that. The other thing is, we're looking at this, and for security reasons, and you can't see one side of the farm from the other. So I think if you have a house at the road end, you can see most of the land in the holding. So that would actually add to the security of the livestock, and the points that Councillor Dryborough made with regard to more crime happening in countrysides where we've had rustling in various locations. So I think if we could cover that situation, that would be a good idea. We also had, not that long ago, biosecurity issues, and to have a bit at the end of the road where you could actually monitor biosecurity so you don't have any outcomes like last foot and mouth, I think that is a worthwhile facility. So I would be supportive of this application.
Any other members? Jim?
Chair, I'll support Councillor McKee. I think we're in a situation where we find ourselves granting unlimited applications on the basis of farm security, and I don't think that's right. I think we have to apply policies. It quite clearly says in this report, there have been no change in local or national policy in the time since the previous identical application was refused. There's also been a reduction in the size of land holding and labour requirements. Previous application and additional information has come to light which has further weakened any proposed justification. For me, that says all that needs to be said, and we need to be sure that we're applying policy in an appropriate fashion and not just in random approvals that will simply open the floodgates for unlimited application on the basis of security or some other perceived risk. So I'm happy to second Councillor McKee's motion that we go with the recommendation.
Archie?
Thanks for letting me back in, Chair. I think that this is what was useful about the actual site visit, is some of that information was given on the actual day because questions were asked. There was no judgments made or anything like that. There were particular issues with regards the viability of actually building a house in the homestead itself, and that's where the electricity and all that comes into it. So the situation in 4.5 states quite clearly that we need to take that into consideration if we are to, apply this application. I've got nothing more to say, Chair, except I will be voting as is.
Any other members? We've got a motion, we've got an amendment. No, the vote, Lucy. Would you like to come in, David? David?
Can I, it was just to sort of summarise, I've been noting down the comments I was hearing from elected members there. If I'm right, Councillor Dryborough, together with Councillor Carruthers' motion, is effectively saying that it's an approval as an exception to policy on the basis that there's a labour report that indicates over 2 labour units because of the topography of the farm unit. It would, putting a house in this location would increase security, and the alternatives such as the conversion of barns are either required for existing operations or would involve undue additional cost, which make them unviable. Is that a fair summary?
Yeah.
Vote with you.
Okay, we have a motion put forward by Councillor Dryborough and seconded by Councillor Ian Carruthers to allow the application to be granted as an exception for policy on the basis that there is a need for a full-time farm worker. It relates well to the other properties, and there is an increased need for security, and also on the basis of a labour report, and that alternatives such as conversion of barns have been considered but have not been, these are not possible. And also, just coming on to that, this would be subject to a Section 75 tying the dwelling house to the land with the occupancy condition and standard conditions required by consultees. And we have an amendment by Councillor McKee and seconded by Councillor Dempster to go with the recommendations as per the report. Now proceed to the vote. Councillor Martin.
Amendment.
Councillor Dempster.
Amendment.
Councillor Crothers.
Motion.
Councillor Dick.
Motion.
Councillor Dryborough.
Motion.
Councillor Geddes.
Amendment.
Councillor Hislop.
Motion.
Councillor Maitland.
Amendment.
Councillor McCoughtry.
Amendment.
Councillor McComb.
Amendment.
Councillor McKee.
Amendment.
Councillor Syme. Councillor Thompson.
Amendment.
And I can confirm that the amendment carries with 9 votes to 4, and therefore the decision is to go with the recommendations as per the report, and the application is therefore refused.
Thank you, Lucy. Can we go to item 5 on the agenda? Dumfries and Galloway College site, Herries Avenue, Heathhall, Dumfries. Erection of 75 dwelling houses, construction of roads, drainage, formation of landscaping and open space. Application for approval of matters specified in conditions 2, 3, 4, 5, 6, 7, 8 and 18 of planning permission in principle in the 13/B/3/0362 and 15/B/3/0513. And we've got Chris McDear speaking to this one. Whenever you're ready, please, Chris.
Apologies for that. Thank you, Chair. Before I begin my presentation, I would like to make a verbal correction on a point of detail on page 21 of your committee paper. Paragraph 1.1. The height of the earth bund is shown as 3.5 metres when it's in fact 4.7 metres in height. In addition to this, the Planning Service have received late material representations to this application from objectors and from the applicant in response. In the interest of fairness and transparency, in order that all the members have the correct information and the relevant material considerations available to them, these have been published on the Council's web portal. The application in front of you today is for the erection of 75 dwelling houses on the site of the former Dumfries and Galloway College in Heathhall. The application site has in principle planning permission for a residential development, and this application is for approval of the matters specified in the parent consents conditions. In addition, the Council has designated the application site as an allocated housing site within the adopted local development plan. Turning to the detail of the conditions, this application seeks approval for matters specified in conditions 2, 3, 4, 5, 6, 7, 8 and 18, which relate to layout, design, external appearance, landscaping, noise assessment, affordable housing, details of boundary fencing and details of junction improvement works on Herries Avenue. Conditions 2 to 5 are standard detailed matters conditions required as part of a further application, and the layout, as you can see from the slide, comprises 75 dwellings arranged roughly within 3 blocks, separated by the 2 main access roads from Herries Avenue, and they form a mix of detached, semi-detached and terrace properties of single and 2-storey design. Open space provision within the site includes several pockets around the northern and southern boundaries and includes a main area covering approximately 4,500 metres square, and this will contain an equipped children's play area, planting and footpath connections into future phases of the site. The streets within the development effectively form a central loop consisting of the 2 main access roads linked by a new road to the rear of the loop. The 2 pods of housing in the north of the site will be accessed from the new northern Herries Avenue access road, whilst the southern access will be from a new improved junction layout. As you can see, this is the existing access to the site. The new road accesses will have full width 5.5 metre carriageways and footpaths with connecting roads being narrower with the use of pinch points created by on-street tree planting and visitor parking in shared surfaces, which will reduce traffic speeds and provide a permeability of movement within the site in line with the government's designing streets principles. Condition 6 of the parent PIP requires a noise assessment to be submitted in respect of the detailed layout relative to Catherinefield Industrial Estate and includes suitable acoustic attenuation measures. The applicant's submitted noise report recommends an earth bund of 4.7 metres in height and topped by a 1.8 metre acoustic fence running along the southern boundary of the site adjacent to Catherinefield Industrial Estate as being sufficiently robust enough to create a residential environment. The Council's Internal Environmental Health Service were also consulted to obtain an impartial view of the submitted noise information and then offered no objections to the scheme. Condition 7 of the PIP requires that at least 25% of the total units on site should be for the purposes of affordable housing unless otherwise agreed. Following adoption in 2014 of the new local development plan and the updated local housing strategy, the requirement for affordable housing has been revised to 20%, and in this instance 15 units from the 75 have been allocated as affordable housing and will be provided on site by Dumfries and Galloway Housing Partnership. Yep. Condition 8 of the PIP requires details of a secure boundary fence or other enclosure to be approved prior to commencement of the development, and this is shown in yellow along the southern site boundary and consists of a 2 metre high anti-climb mesh fence. Condition 18 of the PIP requires the submission of details of improved junction works at the southern site junction on Herries Avenue. The Council's Internal Road Service has been consulted on this arrangement and are happy that the required technical standards have been met. In conclusion, the proposal is considered to be compliant with the provisions of the Council's adopted development plan, and it is recommended that for the reasons outlined in the report that this application is approved subject to the conditions listed on pages 44 and 45 of your committee papers. Thank you.
Thank you, Chris. Members, points of clarification? None? What, David?
Just along that leg that seems to be there on the, just on the drawing of the plan, is it intention in the future to build along that area, or is it just a play area and the trees and bushes, that sort of thing?
The area of open space is, yeah, it's to be retained as open space for the development. The play area will be there, but there's footpath links into future phases of the development. But we haven't had any sort of further detail with that. But we would expect you know, the submitted plans to show sort of future proofing of the development going forward. So we would expect that detail to come forward in the future. Yeah.
Chair, by agreeing, if we agree this today and agree the conditions, are we saying that those conditions would be the conditions that would be placed on phase 2 if they were in a different area of the site? Because the ones that are there just now are in line with the back of the Heathhall primary, if you look at the sort of thing, and therefore you're actually surrounding the site. Would the same conditions actually cover any future, or would it be a case of when the next application comes in, if there was a change in, like, sort of, if it was a noise assessment is actually going to be more because the houses are nearer, would that then be a case of we then adjust conditions at that time?
David?
Thank you, Chair. This basically is an application for the western side and running along the bottom of the southern side of the site, which would have the respective fences on it. So the conditions pertain to this current application only. Any future application would have to be looked at on its own merits, and any conditions that are appropriate would run with them. Obviously, the continuation along the southern boundary would be covered by this one, and it would be required to be retained from this current application, but any additional works would be looked at with a separate application that might come in.
David? Any other members?
Yeah, it's just within the report, it makes reference to you know, the change from 25% to 20% of affordable housing, which varies from the original planning permission principle, but and then it also makes reference to the developer contributions, which is now part of our policy. We seem to have relaxed one requirement and not applied another, even though both are down to a sort of change in how we apply policy, if you like. So why have we chosen to relax one and not apply the other?
They both reflect changes in council policy. The affordable housing requirement at one stage was 25%, but now it's across the board at 20%. So it would be unreasonable to apply the standard historically when there's been a material change in circumstance. Similarly with the developer contributions, we're taking a pragmatic stance, and as far as the EEI committee's decision earlier in the month is a material consideration for us going forward for smaller developments, but for the larger ones it's obviously applicable where it is still relevant.
Stephen, back.
Yeah, okay, thank you. I mean, what you've explained there is what has happened, but it's not the rationale as to why we've applied one and not the other. So when you say pragmatism of not applying our current policy to this, it's really just that disparity. So we've chosen to do one, we've not done the other, yet both are policy. We've relaxed one, and we're it's an inconsistency, is really what I'm trying to say.
Well, again, I'd probably just direct you to paragraph 4.28, which does set out the background to that. Because this is an approval of matters specified in conditions application, we can't go back and attach more onerous conditions than were attached with the parent planning permission principle. Does that make sense?
I totally accept that. However, we have gone back and relaxed one of the conditions.
Again, because there's been a material change in council policy.
Any other members? Nope. Right, thank you. Could I have Alan Cameron, please, Brown Brothers? You've got 5 minutes, Alan, and I'll let you know 30 seconds to go.
Good morning. Alan Cameron, Environmental Manager, Brown's Food Group. Brown Brothers have 9 sites in Scotland, one of them being in Heathhall, Waterbeck, Dumfries, and 2 in England. We predominantly do food, cooked meats, barbecue products, sausages, ready meals, etc., etc. We own the brand Halls of Scotland, for those of you who don't know. In Catherine Field, we currently employ around 10 people at present, but overall we employ well over 1,000 people. We've also been in Catherine Field for around 12 years. Back end of last year and this year, we've had architects down from Edinburgh looking at plans to develop, extend Hangar 2. This is predominantly because we have some ideas that we're really closely looking at present. This could mean approximately 40 jobs being created in this area. At this stage, I can't say anything further at present, but it is something that we're looking at very seriously, and obviously we're looking at this outcome as well. Part of the reason is future growth, and also the fact that we have rented out Hangar 3 to Logoplast on a long-term deal, so we are now looking at other options. We have submitted a letter in already Browns are concerned about noise issues. In my role in Browns, I've seen it time and time again with numerous sites that we have up and down the country. We've already received some noise complaints in the area, predominantly from just vehicles maybe being parked in the wrong place or whatever. And in our opinion, this development is likely to cause even further noise complaints as things stand. The man who drafted BS 4142 section on BSL thinks the applicant has got it wrong. If anyone knows what was meant, it is he. There is also a generous provision of housing in Dumfries up until 2024. It was myself really that brought the Logoplast deal to Dumfries. It was myself that predominantly brought and assisted Logoplast with them being able to create jobs in this area, and I feel quite proud of that. I also, from a personal point of view and from Brown's point of view, want to be here today to support Logoplast because they have done a long-term deal with Brown's Food Group, and at the end of the day, it's important for them and then also important for Brown's and for our future decisions that we're going to make. Class 5, in our opinion, means Class 5, and in Brown's opinion, there are other more suitable developments elsewhere for a development like this. One little thing that I can say to you is that the Belcher's factory in Prestwick, we had one lady who persistently phoned up and complained about odour. Odour, noise, etc., etc. Same things. They bring the same issues and problems. I've yet to see a residential property picking up any invoice or anything to prevent. It's always the business that picks up the tab. This lady phoned up regularly every month, which meant me driving in from Dumfries up to Prestwick to meet SEPA.
30 seconds to go.
And basically deal with issues. She left the area, the thing was put to bed. Right, that was it. Planning in principle is a conditional on assessment in accordance with BS 4142. This is not in accordance with BS 4142, so it should be refused.
Thank you, Alan. Members, any questions? Ivor?
You said currently you have received noise complaints. Would that be from the Wellington Avenue area, or is there another area of the development of Heathhall that you're getting those complaints from?
Wellington Avenue.
No members? Right. You may take your seat, Alan.
Thank you.
Could I have Gary Gray, Logoplast, please? You've also got 5 minutes, Gary, and I'll let you know 30 seconds to go.
Okay, thank you. Good morning, my name is Gary Gray. I'm the factory manager for the Logoplast plant over on Catherine Field Industrial Estate. Logoplast as a company has been going since 1976. It's a 40-year-old company. We have 60 plants around the world, supplying a large number of blue chip companies. We supply all the Heinz ketchup bottles, all the Fairy liquid bottles, Lucozade and Ribena from sites in the UK to the whole of Europe. In terms of the Dumfries facility, the project started in 2014. I was project manager for the site, ultimately ended up as plant manager. We employ 27 direct local staff on site at the moment, working a 24/7 shift pattern. We also work with local companies such as Currys, who do our transportation across to the dairy at Lockerbie, and we supply 100 million bottles per year to the Lockerbie site, with the potential for more, depending upon their requirements, the future business that they may take. We managed to get the contract from a company based in Glasgow, so the original all supply into the Lockerbie site came from Glasgow. It now comes from locally from Dumfries. In terms of the project, as I say, it started early 2014, and the consideration that I took in when we were doing the project was to install all the machinery, all the noise generating machinery, both internally and externally, as far away from the present housing development that's there at the moment. Wasn't a requirement of the planning application or planning permission. It's just something that we did as a company to minimise the impact on the local community. So as a result, I'll show a video towards the end which will show you how that factory is laid out. As it stands at the moment, since the noise survey was carried out, we have installed a further machine, a fifth machine to the site, and on top of that we've had this associated plant and equipment, so compressed air, chilled water facilities which are installed outside. So that's generating more noise. Future plans, there's 2 new projects that Logoplast are looking at for the UK in particular. Decisions haven't been made on those. I think hands have been shaken on one of them, and they're looking at certainly putting one of these projects into Dumfries. Obviously nothing's guaranteed, but there's 2 sites available for that project. One is in Dumfries and one is right down in the south of England. So the hope is that we'll get that project. Now that project, in terms of noise, involves the manufacture of plastic beer containers, manufactured from a plastic product called PET, which you may have heard of. The process of manufacturing packaging from PET is a lot noisier. The compressors used are 4 times as large as the compressors that we've got at the moment, and provide a lot more air, and consequently they provide a lot more noise. And you'll see from the video that will show that the only place we can put those compressors is towards the other end of the building. There's nowhere else to put them, which puts them a lot closer to the development that's planned. So from my point of view, from Logoplast's point of view, if this planning application is approved and it goes ahead, there's a high chance that certainly this second project won't take place in Dumfries, because ultimately, if it's approved, we'll still get complaints, and the onus will be on the company to put provisions in place, and obviously ultimately cost in place to reduce the impact. Okay, so we can just show the video. This is a picture of the factory from inside. So behind. Sorry, if you can just show the picture again for me too. Sorry.
30 seconds to go.
Yeah. So behind is the school. To the left is the development. You can just show the first video for me then, please. Please, yeah. So the development is through those windows. The louvers that are mentioned in the planning application are actually above the windows. And you can see that the storage of the bottles is up at this end of the factory, as far away from the present development as possible. And the noise generating equipment is down that end.
There's 5 minutes up.
There's 2 machines running at that point, not 5. So with further machines being installed, that'll be obviously a lot louder. And I think I've used my time. Thank you.
Members? Any questions, David?
Could you show us where that factory is in relation to the houses at the present moment, please? It might be worthwhile if you could show us Brown Brothers as well.
Any other questions? Nope. Thank you very much.
Thank you.
Could I have Adrian Maitland, please, Catherine Field Properties Limited. You've got 5 minutes, and I'll let you know 30 seconds to go. Just whenever you're ready.
Good morning, Chairman and Councillors. My name's Adam Maitland and I'm a Director of Catherine Field Properties. I'd like to hand over to Craig Welton of Burness Paul to discuss the legal aspects of this application on our behalf. Thank you.
Thank you. By way of introduction, committee, I've represented Kelwood and Catherine Field Properties on this matter for a number of years, including attending the appeal hearing in 2014. This application is before you following the rejection of an earlier scheme by this committee against officer recommendation. That proposal was then subject to detailed scrutiny at appeal, where the Scottish Government reporter agreed with you and upheld the refusal. As in 2014, you have been provided with a lot of information on noise impacts. The applicants are saying that noise issues have been resolved, whereas Sandy Brown Associates, E2 Environmental and John Grant have all raised concerns. I would simply ask members to bear in mind that they were presented with a similar position in 2014, and then Sandy Brown's assessments were preferred to those of the applicants. The Council's position on this site was confirmed by its QC at the appeal, where it was explained that as far as this site was concerned, the principle of residential development does not entitle or allow the appellant to develop what it chooses on the site. In granting planning permission in principle with conditions attached to it, the planning authority recognised that there are constraints on the development of the site and there are requirements which have to be fulfilled. On the question of noise, the Council's QC confirmed that the test was that the level of noise would not result in an unacceptable level of amenity for future occupants of the proposed dwellings. That remains the test for this application. Last time it was clearly established that the applicant and the environmental health officer had seriously underestimated the potential impacts from Catherine Field, and it is fair that the applicant has taken steps in response. However, since 2014, a major new operator, Logoplast, has started operating on the site. This has introduced a perfectly lawful but major new noise source that was not there in 2014. As the EHO notes, the applicant has not assessed all noise impacts from Logoplast, specifically no consideration of the filling of silos considered to be the noisiest activity. It's also the case that even if you allow for the assumptions made by the applicants, the noise case is at best marginal. It's noted by the Council's EHO officer that there will be significant impacts at night and when Logoplast silos are refilled. It's also accepted that increases in activity at Logoplast would require further mitigation measures to the housing that are not part of this application. The applicant and the EHO officer have made a judgment call as to whether impact should be deemed acceptable. Central to that is a reliance on existing housing and a primary school near the site. A similar argument was run at the appeal and rejected by the reporter. The reporter's view was the fact that noise impacts may occur in an existing property was not an excuse to provide a lower standard of amenity for new housing. So far as the primary school is concerned, the reporter was very clear that she, and I quote, did not consider that the construction of the school sets a precedent for lowered expectations of residential amenity. The EHO officer's assessment has discounted impacts from Kelwood's business because noise from a compressor would be considered new. Again, a similar approach was taken by the applicants in the appeal and was rejected both by this committee and the reporter. No questions were asked of Kelwood as to what their business was, and the statements in the report as to what are considered part of that business are neither informed nor reasonable. In reality, this is a Class 5 general industrial manufacturing business which retains the ability to operate 24 hours a day, 7 days a week. You will no doubt be told that existing properties could complain but don't. That argument has been tried and rejected. Simply put, two wrongs do not make a right. Condition 6 is clear that assessments must be made against BS 4142. The Council's confirmed position is that noise must not create an unacceptable level of amenity for occupiers. Applying BS 4142 correctly, it is clear that this requirement is not achieved. The EHO's assessment depends on an assumption that people will not use their gardens after 11 p.m. In 2014, this committee rejected a proposal for housing because it had failed to properly consider and address noise impacts. The committee's decision was endorsed by the Scottish Government reporter. This application repeats many of the mistakes made in 2014. The noise assessments focus on complaints rather than amenity and make assumptions about Kelwood's business that are not correct. If you were to give the benefit of the doubt to either the current businesses or the applicant,
Could I ask you to wind up, please?
I would urge you to give the benefit of the doubt to the existing businesses. Thank you.
Very much. Members? President Ivor?
You've asked us to give the sort of benefit of doubt to the existing businesses, so are you saying by that that we shouldn't consider future development? Because that would say we have to base our facts on what's there just now. We've got a promise or a throwing a sort of hook out there for us to try and say there might be additional business, so we can't take that into consideration because you've actually said we should look at what's there just now, not in the future.
Thank you. What I'd say in response to that is that it's apparent that the noise assessment is at best marginal, and you're being asked to make a series of assumptions and rely on a series of predictions by the applicant. If they are wrong in those, then there are very serious consequences potentially for the businesses. It is open to the applicants, as they've done, to go away and improve their scheme and create more headroom between the noise impacts on their proposed development and what's put forward to you today.
Okay, Ivor. Members? No. Thank you very much. You may return to your seats. Could I have Jamie Maitland, Kelwood Engineering, with Graham Cunningham, Sandy Brown Associates, and Craig Welton of Burness Paul LLP in attendance? And you've also got 5 minutes, Jamie, and I'll let you know 30 seconds to go. Just whenever you're ready. Just whenever you're ready.
Are we going?
Yeah, just whenever.
Sorry, good morning, Mr. Chairman and councillors. I'm Jamie Maitland, the Director of Kelwood Engineering Limited. We're a Dumfries-based company, always have been, established 32 years ago, operating on Catherine Field Industrial Estate. We're right on the boundary with this site. We currently employ 50 people, mainly time-served tradesmen. Concern has already been expressed that the noise levels have been materially understated by the developer and in the reports going to council. Logoplast wrote to you describing where the current application falls short, but it is worth repeating some of our conclusions. Condition 6 of the PIP requires this application to be assessed in accordance with British Standard BS 4142. To try and resolve a dispute about how to interpret the standard statement on background noise, I sought, and have now received, a report from the man who wrote the section on background noise. He states that the applicant and the council have misinterpreted the British Standard and overstated background noise by 3 decibels. This becomes very, very relevant to what I say later. And now, I plead with you and apologise with you. The next bit is a short technical bit. If you can bear with me, please. BS 4142 says background noise level plus 5 decibels indicates an adverse impact. Background noise level plus 10 decibels equals a significant adverse impact. The council's noise assessment, which has been made available to us, says that Logoplast high louvers are rated at background plus 8 decibels. That's already an adverse impact, and complaints are likely. Next, the reporter said business on the estate should be given some headroom for growth. This is what we were talking about, which Craig Welton was just mentioning. The Environmental Health Officer omitted this from his calculations. The applicant didn't, and the applicant has allowed 3 decibels. And so presumably that should be allowed. Now, if you're still with me, we're now up to background noise level plus 8 decibels plus 3 decibels. That's background plus 11 decibels. And if you were listening very carefully, you'll remember that 10 decibels equals significant adverse impact. Gets slightly worse because of the noise report we've just had defining how they should have calculated background noise level. Because it should have been 3 decibels quieter, we are now really at background 8 decibels as calculated by the Environmental Health Services, plus 3 decibels, headroom for growth, plus 3 decibels, which is the adjustment to the background noise itself. So we're at background plus 14 decibels. And you'll remember that 10 decibels is equivalent to a significant adverse impact. Councillors, at 14 decibels, you're going to have the residents on your phones complaining, and the employers on the estate will be at risk. Members will recall the anxious delegation of Heathhall householders at last month's planning meeting. They were concerned about noise. To sort that problem, Environmental Services stipulated a condition requiring that rated noise level from the development shall not exceed the background noise level by more than 5 decibels. Not 14 decibels, councillors, 5 decibels. I suggest that the occupants of this development deserve the same protection. You're to be congratulated. This committee should be congratulated. Last time we were here, you went against advice and refused the application.
30 seconds to go, Jamie.
The reporter agreed with you, and since then the applicant has tried to make things better, but the acoustic landscape changed with the welcome arrival of Logoplast and its 30 jobs. Unhappily, many of the same mistakes from the last application have been repeated. In conclusion, the noise survey associated with this application has not been carried out in accordance with BS 4142 and therefore does not comply with condition 6 of the parent PIP. On that basis, the application should be rejected. Thank you.
Thanks very much. Members, Archie?
Sorry, can I get my hearing aids back in, or I'll...
Mr. Maitland, can I ask you a question on the background noise level that you just mentioned there? You said that at the moment it was at 6 decibels and then there was plus 3 and then plus 3. In actual fact, noise, as you're well aware, travels in waves, and potentially that noise could actually be muffled by the 6 decibels rather than added on to. So are you saying, or are you of the opinion that the new development would increase the noise, or would it be muffled by the existing noise that's actually on the site already?
I'm not sure I understand the question. The noise is coming off the industrial estate. We are the noisy ones. They are termed as, what is the term for?
Specific noise level in terms of BS 4142.
They're the recipients of the noise and the ones sensitive to noise. So what BS 4142 is about is calculating how the noise we on the industrial estate is rated, is effectively perceived at the houses. Does that help?
Ivor?
If we allow for, was it 14 decibels, I think you said, was the possible uplift in the figures we have, what's the impact on current residences within Herries Avenue and Wellington Avenue? They would have the effect that if you were to develop your business, would they not be entitled to the protection as they currently exist, whereby you would have to put attenuation in anyway to come down to the levels required? So even if this development wasn't here, if you actually put a new development on site, you would have to take into consideration the current houses that are already on site.
You're talking the law of nuisance rather than planning once you get there, and that is perfectly right. The reporter was very clear. She said that the state of the current properties should not be an excuse for lower amenity in the new ones. And I am, as the Environmental Services noted, the noise from the silo is hearable down Auchencairn Avenue and another of the streets there. Yes, I can say nothing more. We are not attractive neighbours. Instinctively, this is a Class 5 industrial estate which is defined as it shouldn't be next to private property.
Okay, anyone else? Ian?
Could I ask you, Mr. Maitland, what impact you think the proposed earth fund and noise reduction fence will have? You didn't make any mention of that, but I just wonder whether they may have gone far enough.
The calculations I was doing, where we started with 8 decibels over the background noise, had already got an allowance for 3 decibels of attenuation as a result of the bund.
Okay. No other members? You may take your seat, Jamie.
Thank you. Thank you.
Could I have Adam McNally, please, the applicant, with Ryle Swales and James Shiazi in attendance, please? And you have 5 minutes, Adam, and I'll let you know 30 seconds to go.
Good morning, members. My name is Adam McNally from Story Homes. Here today with James Serazi, DHP, Ryan Swales, our noise consultant. Quickly move on. We fully believe our evidence stands up to the technical scrutiny. Aside from the technical matters, just want to reinforce the following points. As per your policy H1, the council is to support housing development on allocated sites. The local plan further states development of this site represents a logical extension. It's close to your range of services. It is an allocated site, it is a brownfield site, it even has the benefit of permission in principle. So what we're proposing here today is a phased approach, starting with 75 dwellings based around a concept master plan. We've got the support of planning officers, environmental health officers and roads officers, and it's fair to say we've worked tirelessly over the last 16 months in which to please them. The result really is a highly attractive and functional first phase layout, which will lead the way to the next phases to come. We are proposing a noise barrier totaling 6.5 metres in height. That is to be attractively landscaped with native shrubs and trees. The erection of the new barrier has meant we do not require any plot mitigation for the proposed 75 houses. There will be no legitimate land use conflict with the industrial estate. We've carried out robust noise assessments and modelling which proves this. There's no justifiable evidence that the land beyond cannot come forward. We estimate across the whole site, working in partnership with DGHP, to deliver around 180 dwellings into the future. That's below the 192 allocated housing site and indeed below our previous application for 207. There's many economic, social and environmental benefits. Mentioning the redevelopment of brownfield site, the attractive screening to the industrial estate. We will have security fencing for the industrial estate, new quality homes including affordable homes. There will be bungalows on Herries Avenue, natural traffic calming in accordance with design for streets, plenty of parking, new play area central to the scheme. There will also be a large area of informal open space, which will be part of the buffer zone to the industrial estate. We will provide acoustic enhancements to the wider area, including Herries Avenue, property is already there. This will be a highly desirable place to live. And in terms of your noise, the condition 6 rightly does not require all of the details to be submitted for the full site. It allows for consideration of a phased approach. We would come back in with further noise assessments, which this condition would require for future phases. There's no evidence to suggest the future phases can't come forward. We know environmental health and thinking of the future phases have recommended a distance of 75 metres to the louvres. Looking at our concept master plan, we're looking to achieve potentially 115 metres directly facing. So in conclusion, we feel it's thoroughly in accordance with your noise guidance, BS 412 from 1997, and indeed the 2014 standard. We will have Ryan on hand to answer questions in that regard, but I'll move over to James Serazi from DGHP.
Good morning, councillors. And just to confirm that I'm not an objector and I'm not a noise expert, so I'm just talking about the affordable housing in this proposal. One of the objectors unfortunately said that there is no housing issue in Dumfries and Galloway. Well, I beg to differ. It's the number one priority, is the government's priority for building 50,000 homes across Scotland. Dumfries and Galloway, the Common Housing Register has 7,500 people on the waiting lists. In Dumfries, it's 4,500, is the highest demand area. And in Lochabriggs alone, we've got 600 people on our waiting list applications. In the proposals, we have some gold standard housing that we have attracted money for, that the government have given us money for. Now, gold standard is mostly energy efficient projects that can, wax lyrical for a long time, but it also provides lifetime homes for people with disabilities. 75 of the houses that are being proposed is 10 million. This investment has been secured, and this will be carried out with 100 jobs. It's a mixed tenure proposal. Obviously, Story Homes will do all their direct sales. DGHP also provide MMRs. These are with families and households with jobs. New supply shared equity. This is to allow newcomers into purchasing housing with 40% discounts. And obviously, our affordable housing.
30 seconds to go.
Thank you. The SHIP, this project is proposed on the SHIP as a priority. I appreciate there's a difference between planning and housing sub, but this project is on the Strategic Housing Investment Programme approved by the Council. I said I'm not a noise expert, and obviously we're going to propose and say that there is no noise issue. The objectors are saying there is a noise issue, but in this circumstance, the Council's the only really objective.
Can you wind up, please, Jim?
And they are saying that there are no noise issues in the proposals. Many thanks.
Members? Ian?
Mr McNally, could you comment on the assessment that Mr Maitland had made about the decibels? He seemed to be very specific about it. What would your response be to that? That there was a 14 decibel point?
Thank you, Member. I will hand over to our noise consultant, if I may, Ryan Swales, who can tell you more about that.
Oh, hello, councillors. Mr Maitland was alluding to the fact that when you penalise a noise source for a specific tonal character, you would add penalties. So 2 decibels, is it perceptible for a prominent tone, for example? Is it intermittent? You add a further 3. But one thing I need to make quite clear to this council is, although there's a sliding scale of penalties and penalties for different aspects of the tone, you don't always simply add them up in a linear fashion, because that would leave room to add up to the standard to have 15 decibels above the background noise level. And there's been studies and conferences with the Institute of Acoustics, of which I'm a member, to say that that's inadequate or inappropriate to simply add all these penalties on a sliding scale. There'll be a point where one aspect of the sound is more dominant than the other. If you can hear a clear tonal aspect, it might not be that the intermittent nature of the source is what picks up in your, is what you perceive.
Archie?
I think that was the question I was asking. At the moment, there is a background noise anyway. If there was a noise added, it blends in. This is layman's terms. It blends in with that existing noise rather than adds to the noise. Is that what you're saying?
It depends. That's correct. It depends on the characteristics of the noise source. But yes, it's depending on the ambient characteristics of the noise environment. It might not just stand out. It will blend in depending on the type. It comes down to actual type of source. Really, you'd have to look at the actual noise source in question and take detailed measurements to see if it can coherently merge with the actual background.
But I mean, there's a lot of focus on the noise here, rather than the standard of housing. And the standard of housing will have a standard to prevent noise actually going into the houses, I would assume. How is that standard measured, and is there a British safety standard and that kind of thing?
BS 4142, which is the principal assessment for this condition, talks about ratings and identifying adverse impact. The standard with regards to the quality inside your home and the acoustic environment and acceptable conditions for sleeping and good health, etc., are under the WHO guidelines and BS 8233, which will stipulate, for example, 30 decibels for a bedroom is a good standard, 35 is a reasonable standard, living rooms, for example, in the day is 35 for good, 40 for reasonable. our assessment has shown that when we take into account the total level of sound from all sources combined, of which we've done a very detailed 3D acoustic model, and neither the objector nor the consultants have done that exercise, we've shown that we're considerably below those standards in terms of betterment. So, for example, if we've got 30 decibels as a good ideal standard in a bedroom at night, our assessment is showing that we're at least 10 decibels below. So once the reality is, in aspects, you won't even hear the noise once you're in your bedroom with the window open.
Tom?
Yeah, that's a question I was going to ask. I've had some experience with the issues in my area with noise and smell, etc. It's all very well saying you've got things that you've got standards for noise, but are all your windows going to be fixed? Or will people be able to open the windows? Because there's quite a difference between having a standard when the windows are closed, as you will be in the winter time, but in the summer time, no matter what, folk will always open the windows, and they will leave them open through the night, never mind through the day. So do these standards mean an open window or a closed window?
We've looked at both scenarios, Council. We've looked at the noise ingress with windows firmly shut, and we've looked at the scenario with the window open, and with the window open, we'll be considerably below or betterment of the ideal standards. The scheme and the proposed dwellings are based on being naturally ventilated with an opening window, not having sealed windows or mechanical ventilation. Indeed, we feel it's not necessary, given the height of the bund and given other measures such as orientating houses or habitable rooms specifically away from the louvers at Logoplast. If you look at the plan, the architect to a degree has orientated as best as practical houses away from Logoplast louvers.
Jim?
Thanks, Chair. All of these houses, proposed houses, have gardens. How do the noise standards relate to people out in the open? You know, we've seen there is an extensive area of open space planned for the development.
Again, the World Health Organization guidelines recommend that noise levels don't really exceed 50 decibels within the garden areas to avoid annoyance, with an upper limit of 55 decibels where you would potentially have serious annoyance. The results of our assessment, our very thorough detailed noise modelling, has shown that we're going to be considerably below 50, in the mid-30s, in fact, within the gardens nearest to Logoplast.
Yeah, any other members? Nope. You may return to your seats. Members, we're now in session. Ian?
Because of the comments that we made, Chairman, I would move that we have a site visit.
I think, you know, rather than a site visit, I think a lot of what we've heard today is technical. And ideally, I mean, I would suggest that we as members should have a wee bit of a training session on noise. A long time since I studied noise when I did physics. I'm well aware of the 1 decibel and 2 decibels are a fair difference. I think it's multiplied by 10. So I think that the whole thing seems to hinge on the noise issue more than anything else. And although we get training in various other aspects of planning, the noise issue, because it doesn't arise very often before the event, it's usually after the event. And I really think that as elected members, we should have some degree of training on the technical aspects, because that's what's all been hinging around this morning, both from the applicant and the objectors.
Alistair?
I think it's very true indeed, Chair, that the issue is in fact hinging on the noise impact, likely noise impact on an effect on the proposed housing. I was particularly mindful, or I'm particularly mindful of the comment that was made earlier that give the benefit of the doubt to the existing businesses. Well, the first thing I would say in relation to that is that there most certainly is a significant element of doubt here. And quite frankly, without indulging in melodramatic language, if we approve this application today and the fears of the objectors are realised, this will be nothing short of a catastrophe. And I think that, you know, I've no problems with the concept of a site visit. I'm not entirely sure, give us a better knowledge on the ground, and from a topographical point of view, I'm not sure if you can teach an old dog such as myself new tricks in relation to Tom's seminar on noise issues. I think, without being patronising to Mr. Maitland, he pitches at a level which I, as a layperson, was capable of understanding. And as I say, I would commend them for that. But at the end of the day, I make no apologies for repeating that we've got to get this right. In my mind, there is a significant degree of doubt. And if we don't get it right, it will be, as I say, catastrophic. So that's my position at the moment. As always, I will listen to what colleagues and yourself have to say and come to a determination at the appropriate time.
Richard, would you like to come in on this? Anything? No? You? No?
Thanks, Sharon. You know, being an expert on audio is something that will never ever be, I think, as councillors, but it's certainly something that we need to consider as part of the planning application. I think I'm with Ian on this. It might be an idea to actually have a site visit, and if the people that are there can show us where this bund is going to be and things like that. I am of the opinion that the noise is the objectors' issue here. There's no doubt about that. But they're making the noise. And this is about housing at the end of the day, and housing has a standard as well. But I'm all for doing a site visit and looking at distances, not because distances is always part of the reduction in noise and that as well. So quite happy to go along with the site visit. I don't think we'll ever be experts in noise levels as councillors. That's why we've got officers to give us advice on that particular thing. So happy to go with the site visit, Chair.
Are you seconder? Right, got a proposer and a seconder for a site visit. Any other members otherwise minded? No. Site visit, is it? Question is it? Are we? Either you.
Chair,
Yes, a site visit.
would it be possible maybe to have the site visit when Logoplast are filling their silos? That might give you an idea of the actual noise that
might be 3 o'clock in the morning, either.
Well, if that's the time we need to go, because that's when the people will experience the noise if it's 3 o'clock in the morning. Another thing is how, with being on site, we won't have an idea of how good or how bad the acoustic bund will be. So how do we measure that when we're there just for the site visit?
Get them technicals. So we agreed a site visit? Fine. Well, Ian is quick.
No, I mean, I totally agree with site visit, but we just want to, I lived opposite within 30 metres of a sawmill for about 10 years, and I understand the impact that has. Very supportive of business and our strategic plans as a council. But I think, going back to the point what Ivor's picked up on, we need to realise the noise impact, what the potential mitigation is in regards to that, what's the bund, further mitigation, when the type of wind is being used, and that's the type of information I would need for that site visit, and very much appreciate the committee taking that decision today, Chairman.
I know we experience. I worked 30 years in the plastics industry, so I know how noisy it can be. So, agree to site visit.
Just a response to Councillor Hislop. Whilst I appreciate it would be ideal if we can coordinate with the Logoplast silo filling, obviously there's trying to find slots in the council diary is challenging. That, as I understand it, the silo filling is an intermittent event, and therefore trying to coordinate the two might be difficult, but we'll see what we can do.
I think next month's quite empty in the calendar. I think there's maybe a planning meeting, but the rest of the things, maybe a full council at the end of this month.
Something else on? So agree to site visit. David, arrange a site visit. Come on, David, you've been dying to.
Thank you. It's regarding Wellington Avenue, and there's factories backing onto that. Would it be worthwhile taking measurements from there so we can make comparisons?
No, I'll take advice on that. David. We'll take measurements Wellington Avenue. You got that, Lucy? Number 6 on the agenda is the Jane, somebody get Jane back in, please. Jane's there. Very good. Number 6 on the. Remember coming or going? Let's see. Item 6 on the agenda, Smugglers Inn, 9013 Main Street, Auchencairn, Castle Douglas. Applications for A, planning permission for change of use, public house and manager's accommodation to form two dwelling houses, replacement rear extension, 17/0002/FUL, and B, listed building consent for alterations and erection of replacement extension to the rear elevation to bring about the change of use from public house with manager's accommodation to two dwelling houses, 17/0003/LBC. We've got Mary Mitchell speaking to this one. Whenever you're ready, Mary.
Thank you, Chair. Good morning. There are two applications being looked at here. One is for the change of use from a public house to two dwelling houses, and the other one is a listed building consent application. We'll look at the slides first. The site is located centrally in Auchencairn on the main street. It is a two-storey building of traditional construction. It's category C listed. The physical changes to the building aren't significant. You can see there are, this is the existing ground and first floor plans and the proposed ones. Again, the cellar and the attic floors, not a huge amount of change, just enough changes to facilitate the change from public house to dwelling houses. Existing front and rear elevations, proposed front and rear elevations, existing side, proposed side, and the photographs of the site. There's a flat roofed extension to the rear. Some minor changes are proposed to that. It's to be made a bit smaller and a pitched roof put on it, which will improve its look. There's quite a substantial garden to the rear as well. Right. These applications are a resubmission. They were originally heard at the Planning Committee on the 30th of November 2016, where they were refused, contrary to officer recommendation, on the grounds that they are contrary to policy CF1B, reuse of existing community facilities, in that it has not been satisfactorily demonstrated that all other options and possibilities for the sale of the pub have been explored and exhausted. In the weeks following that decision, the applicant offered Auchencairn Initiative a new lease with an option to buy. Auchencairn Initiative rejected this offer. The applicant believes this demonstrates that all the other options and possibilities have now been explored, which is what led to the resubmission of this application. I'll just go over the proposal and the main considerations of the case, which are otherwise as previously submitted. The proposed physical alterations to the building would maintain and enhance the character of the building. The listed building consent is therefore recommended for approval. The proposed change of use from a public house to two dwelling houses has received many objections from members of the community and an objection from Auchencairn's Community Council. The principal policy this application is assessed under is Local Development Plan Policy CF1B, the reuse of existing community facilities. And the pivotal question within this policy is the pub surplus to the needs of the community? Planning officers determined the pub was surplus to the needs of the community because, one, despite 16 months of sustained marketing, there was no viable interest from a commercial operator to buy the property. Two, there is uncertain financial viability in this public house business. Three, members of the community do not so much want a pub as they want a hub. The Auchencairn initiative have been given many opportunities to buy the pub. They have commenced an application for grant funding to the Scottish Land Fund to buy the building, but this application is still at an early stage, and they're not in a position to make a firm financial or other commitment to purchase the building. In the interests of consistency, as well as consideration of the relevant policies, the application for change of use is recommended, as previously, for approval.
Members, points of clarification? Jane?
Yes, it's the issue about the listed building consent. I'm not absolutely clear why we have to agree one without the other. I mean, yeah, let's start with that one.
Thank you, Chair. This is actually something which I have to hold my hands up and say that I missed this last time round because it's a single report that we put up last time, as with this one. There are two applications within it, and I've covered this in paragraph 4.22, just explaining what happened last time, which is that the use was what everybody was focused on, but unfortunately only one decision was made, and that was in respect to the planning application last time, but the decision covered both, if you see what I mean, whereas you can only look at listed building issues for a listed building consent application, so you can only look at the effect of the actual physical proposals on the character of the listed building. Now, as the slides may have showed, the actual proposals are relatively limited and in fact beneficial by adding an improved rear extension with a pitched roof instead of the flat roofed one. So on that basis, if an appeal had been actually submitted, I suspect that not only would it have been thrown out, but there would have been a case for unreasonable decision because the decision hadn't been made properly about the listed building consent and the effect of the character of a listed building. It is quite possible to have separate decisions. And in fact, we've done so in the past. I can think of one case straight away where listed building consent was approved, but the planning application was refused, and obviously one can't be done without the other. So certainly my strong advice here is if members are minded to reiterate their previous decision to refuse this for the planning application, the listed building consent should be looked at only on the listed building issues, and I would strongly suggest really there's no grounds for refusal, certainly not on the not proven thing. There is the solace there that it could not be implemented without the planning permission. So it just would take the whole issue of the listed building consent out if there were any appeal.
Yep. Any member? Nope. Could we have Bill Barlow, please, objector? You've got 3 minutes, Bill, and I'll let you know 30 seconds to go.
So I'm Bill Barlow. I'm the currently leading the project for the Smugglers in Auchencairn. So it was a shock to learn of a new planning application only 4.5 weeks after the rejection of November the 30th. This was only made possible because the applicant claimed there had been a material change in circumstances. There has been no change in circumstances. We are entirely on track and in many respects even ahead of our plan. Since November the 30th, we have been through the lengthy process of selecting a consultant. We've appointed third sector Dumfries and Galloway, who are highly professional and will bring in cooperative and mutual solutions as part of their team. CMS has assisted in 18 other community buyouts of pubs to date, using a mix of grant funding plus community shares. We will now be adopting this same funding strategy ourselves, and we will not be solely dependent on the Scottish Land Fund. Much of the required groundwork for community shares is already in place, including village registration as a community benefit society and preliminary discussions with Community Shares Scotland. Meanwhile, we made a Stage 1 application to Scottish Land Fund for consultants' fee, which alarmingly was returned to us with the request we reapply at a later stage of development. We do not have that kind of time to spare. However, within 1 week, an offer had come from a private member of our community to fully fund the work of the consultant. We have accepted this very gratefully and are immediately back on track with an agreement now in place with third sector to proceed. I wish to stress that we are not looking to replace the pub with a community hub. The latter should be looked at as an additional aspect within a much greater whole, fully in line with progressive community thinking. The pub aspect remains absolutely key to the success of the whole and will be added to, but not in any way replaced. I beg you to note that this is a community-led project run by hard-working volunteers. We are not professionals, though we do now have professional help. We have been doing our best, learning fast along the way. We believe this to be an extremely important example of the new way forward for local communities, unlocking the full potential of local assets and moving us away from the highly inefficient and disaffecting model of the absentee landlord. For us, this is not a commercial game. It is trying to put back together the pieces of a healthy community.
30 seconds to go, Bill.
Finally, I must point out the eyes of the world are upon us. We run a blog site where we publish progress on this project and invite comment. Yesterday, we just passed 4,000 viewings since October. Most are local, but we've also had visits from 7 other countries on both sides of the Atlantic. What is decided to hear will echo far beyond these walls. We can do this, we will do it. The only thing we need is the security of more time. I most earnestly ask you to afford us this one missing ingredient.
Thank you, Bill. Members? Ian?
Mr. Barlow, what sort of timescale are you talking about?
I knew that would be the question. It's as long as a piece of string. If we adopt the community shares model now and don't rely solely on grant funding, it speeds things up a lot. Some community share issues have been resolved in as little as 4 months. 6 months is more reasonable. 9 months is it makes it comfortable. But so I have never been involved in this before. I'm going on guidance, but somewhere between 4 and 9 months.
Any other members? Jim?
Well, the applicant claims that you have rejected an offer to purchase the property.
Right.
Is there a basis for that?
Yes, this is an extremely important point. I'm glad you asked it. Basically, the offer was made to us within 3 weeks, I think, of the planning. No, even less. 2 weeks of the last hearing, the November the 30th. It was a complete surprise to us. We weren't expecting an offer. We didn't ask for a lease. We weren't expecting it. It came out of the blue. Initially, myself and one other met with David Hyland and discussed it. And our first reaction was it was quite sort of a reasonable approach. We were, however, convinced that if we accepted a lease arrangement, we would then be unable to secure.
Can I just interrupt you? Because I was going to give all that information at the next presentation.
Okay.
All right, fine.
So, okay. Well, I won't take too much from Guy's speed, but it was uninvited, unwanted, and we decided that we would stay with the original plan of focusing on purchase of the building. Because there's many reasons which Guy will explain why it's unattractive to engage in a lease. So we turned this down. We've never deviated from our original plan. Mr. Hyland used this as and he projected this as a reason why there was a material change in circumstances. As far as we're concerned, nothing had changed. It was a contrivance, in our opinion.
Yeah. Remember? Nope. You may return to your seat, Bill.
Thank you.
Could I have Guy Pounder, please? Objector. And you've got 3 minutes, Guy, and I'll let you know 30 seconds to go. Right,
Thank you very much.
Whenever you're ready.
Good morning, everybody. I'm Guy Pounder, and I'm the chairman of the Auchencairn Initiative. For those of you not aware, the initiative was set up initially to raise funds for the village projects over 12 years ago. It's a company limited by guarantee with charitable status, independent of the Auchencairn Community Council, despite what Mr. Hyland believes. As you gathered, I'm going to talk about the lease. In November 2016, following the refusal of the owner's planning application by this committee, the initiative was led to believe that we would now have time to concentrate on raising funds to purchase the property. On the 16th of December, the initiative was presented with an unsolicited and surprising lease proposal. The initial examination showed a promising offer. However, the conditions attached included a presumption that refusal to accept the lease by the 16th of January would indicate that the village did not wish to acquire the building. You will have noted that this time period was over the Christmas holiday period and therefore an almost impossible timescale for a voluntary organisation. Mr. Hyland stated that his lease proposal was a result of the chairman of the ACC, the Community Council's benign concluding sentence in the Community Council's letter opposing the 30th of November application, which read, "It may be that the village and the applicant can still find a solution." I do not see how this invites an unsolicited lease proposal. Additional conditions included personal guarantees for the rent from several local people, none of whom, to our knowledge, had been approached by the owners for their agreement. The initiative directors studied the lease and reached the conclusion that had we taken on the lease, we would have been considered as having started a project and therefore would have rendered ourselves ineligible for a grant funding. The risk to the initiative's funds was too great, as it risked being unable to maintain our village shop and our post office, which the initiative owns, along with support for our Link Park, the Hugh Payton Path, the Bird Hide, and the Play Park, all of which are held in trust for the village. The initiative has unrestricted cash assets of around £8,000, and the conditions imposed were therefore unacceptable. In his response to the planning officers to the 33 objections, apart from his own, there were no supporters, to this planning application, Mr. Hyland makes several contentious statements. We contend that the presentation of an unsolicited lease proposal on Friday, 9 days before Christmas, with the expectation of acceptance by a voluntary body which would have required legal advice over the Christmas and New Year period, was unreasonable.
30 seconds to go, guys.
The initiative rejected the lease proposal for the reasons I've already given and needed no legal advice to make that business decision. It was not rejected out of hand. This new application is premature for the reasons given, and many of the village objections reflect that view. The committee can see from the objections submitted there remains a very strong support for the purchase of the pub. In fact, there are 10 more objecting letters this time than there were last time. And we request, therefore, that the committee again reject the application for the change of use, because there's been no material change of circumstances since the refusal on the 30th of November, and there is very strong support for the community ownership of this pub with a hub. Thank you very much.
Thank you very much. The members, any questions? Ivor?
If I was a layperson looking at this, the pub's been closed for 2 years, and in one of the consultation responses, it says it takes about 9 months to put forward an application under paragraph 2.1a. If it's been closed for 2 years, why hasn't this been done back in February 2015 so that you could purchase this rather than coming to the situation it's in just now?
There was an organisation set up within the Auchencairn initiative and a subcommittee that started work on it as soon as the pub closed, because we needed to do that. We realised that we wanted to buy this pub. That committee worked extremely hard, but for many reasons, there was no agreement over the price. And at that point, the difficulty was we could not therefore produce a business plan, or they could not, because I wasn't involved in that. They could not therefore produce a business plan which would stand up to grant funders, because it was an open-ended question as to what the pub value was. And in fact, the pub value and price changed dramatically from 245,000 to 175,000 in a period of about a year. Just doing surveys and all the rest of it and getting the work put together actually broke the people that were working on it. They just were overwhelmed by the work that was involved. And that is why they wrote to Mr. Hyland to say that they wouldn't be able to continue. And at that point, along came Mr. Barlow with renewed vigour, who has taken this project forward and is positive and driving it as it is at the time. It just physically takes time to do that. Maybe we chose the wrong model. Maybe we shouldn't have done it on grant funding. Maybe we should have gone for a combination of two types of funding for it. All of these decisions have delayed us. So here we are now with a closed pub for 2 years. Mr. Hyland says that he has tried very hard to accommodate the village and get them to work towards achieving a pub for the village. If he'd really been doing that, why on earth didn't he look for another leaseholder to run the pub and keep it open? Because an open pub is a much better project than a closed pub. We don't necessarily want to buy this pub. If someone else comes out of the woodwork and says, I want to buy this pub and run a pub, and pays the price that Mr. Hyland wants, we would be delighted. We are, if you like, the last resort to achieve getting this pub back in our village. Thank you.
Remember? Nope. May take your seat, guys.
Thank you very much.
Could I have Bill Barlow, back again, please, reading a prepared statement on behalf of John Simpson, Auchencairn Community Council.
John Simpson,
3 minutes, and I'll let you know 30 seconds to go.
Okay, so John Simpson is unable to be here today and has prepared the short statement. Auchencairn Community Council are still very concerned that the change of use of the smugglers will have a detrimental effect on the viability of our community assets because, 1, the main issues report of the second local development plan indicates the additional land allocated could increase village housing stock by some 25 dwellings. This, in addition to the 15 dwellings in the current local development plan, makes a total of 40 additional dwellings. I guess the point there is that point 2, Auchencairn Initiative are still progressing with the funding plan to purchase the smugglers, and more time would be very helpful. Point 3, loss of the social hub will hasten the demise of the village, meaning more rural decline within Dumfries and Galloway. 4, as Auchencairn is defined as a local centre, the Community Council are working hard to maintain as many local services and amenities as possible, and are concerned that the loss of the smugglers to housing will not help this mission. End of the statement. Thank you.
You've also got 3 minutes, David, and I'll let you know 30 seconds to go. Whenever you're ready.
Detailed information to all committee members. At that time, no contact or further updates have been received from the Auchencairn Initiative since last December. Coincidentally, on Sunday afternoon, I received a phone call from Mr. Bill Barlow updating me on their latest position. In August, Bill Barlow stated that they were between 4 and 6 months away from being able to make an offer for the property. In November, it was stated that it would be still around 6 months before any offer would be possible. The last planning refusal gave an opportunity for the community to explore if they were able to raise the necessary funds. 4 months later, Bill Barlow has now confirmed that he's approximately 9 months away from knowing whether an offer will be possible. Paragraph 4.12 of the officer's report states, it is not reasonable for the planning authority to prevent change of use proposals until public house owner or operator does or does not appear in future years. A financially viable option is required. Recently, the initiative have had their stage 1 grant application to the Scottish Land Fund refused and are now investigating alternative funding sources in order to seek community pledges. In January 2016, when they withdrew interest, there was a lack of confidence that that fundraising method would be successful. This U-turn effectively takes us back to where we started 3 years ago. Please note that paragraph 4.14 of the officer's report states, the application should not be delayed by waiting for funding application results. Policy CF1 is not intended to allow the community a power of veto over such planning applications, but to allow each application to be assessed on its merits. After 3 years and in the circumstances outlined, it would be unreasonable not to uphold the officer's recommendations in order to see if a further changing of fundraising plans are successful. The officer's report follows a detailed analysis against planning policy, and paragraph 4.13 states the pub is surplus to the needs of the community and policy CF1B is therefore satisfied. For a second time, the officers conclude that the application meets all planning policy and criteria necessary for an approval. A refusal would inevitably prompt an appeal, which will be made with the consistent recommendations of your officers and their professional assessment. Thank you.
Thank you. David. Members? Then, may return to your seat, David. Members, we're now in session. Remember, there's two applications here, one for the listed building. Jane?
Thank you, Chairman. I see no particular reason to change my view on my last suggestion, which is, I think, stated in 1.7, paragraph 1.7. The reasons there, the grounds were given. I do not think that alternative efforts to retain the community facilities in the Auchencairn have been exhausted. I think we've actually heard that here again. I think the community is clearly on a pathway to achieve this. I have to say, to have this put back to us within 4.5 weeks of a decision doesn't seem to me to be a particularly reasonable way of looking at our decisions, members. I therefore suggest strongly that we permit the community to try and concur with our own policies, which is to retain community facilities. I think it will become perfectly obvious that it's either going to work or it's not. But at the moment, I think they're still on the trajectory that they said they were going to be. They are clearly making way and making an effort to achieve what we want to achieve with our policies. So I would propose that we go with exactly the same recommendation as we did last time. The only thing there, it's about the listed building consent. Very happy to accept officers' advice on that particular matter.
Ivor?
Chair, I was uncomfortable with the decision we made the last time. And when you actually look at the reasons, the reuse of existing, it's been shut for 2 years. It's not an existing community facility because it's closed. The community haven't been in there for 2 years. If it was such an important aspect to them, surely somebody would have done something by now. I don't think we can stand here and let a building fall down because we're waiting on a possible application to a land fund or whatever. I think we should go with the recommendations contained within the report, both on A and B, with regard to the change of use and the listed building, and remove such.
Ian?
I would agree with Ivor in regards to the recommendations, how we should proceed. I would make comment that if we do approve this today, if that's the case, it certainly doesn't stop the negotiation process. Things could still go forward and the local community could still get the same outcome. I very much agree with the very last comments that if we do refuse this today, if this application gets put to a report of the Scottish Government, it'll get overturned, and it's as simple as that. So I would much rather see this being approved here today and let the negotiations carry on.
Ian?
Thanks, Chair. I would support Councillor Maitland on this, primarily because that's what I had decided at the last application. Had this been 9, 10, 11 months down the line and it came back as this, with clearly no viable alternative coming to fruition, I would probably have changed my mind. But this is what we made a decision at the end of November. If you take out most of December, we're looking at an application back in March. There's not been a reasonable amount of time. That was the reason for the decision, to allow a reasonable amount of time to see if something would come to fruition. As I said, at this point, I don't think anything's changed, and of course I accept the officer's recommendation regarding the listed building status.
David?
Just looking at this, planning permission was given away back in 2009. And I don't see, as Councillor Crothers was saying, I entirely agree with what he said there, that just because we give planning permission today doesn't stop them from continuing on the road down looking to use the facility for the benefit of the community. So I would certainly go with a recommendation.
Like mine, I think if we go with the officer's recommendation, it will maybe galvanise some action, because what I seem to be picking up here, this has been dragging on and on and on now for a quite considerable period of time, and we've had two and a bit years. We're talking another 9 months potentially to maybe get the money. So then we come back again in another year's time and have exactly the same argument all over again. We suggest no. If we grant this today, we go in the officer recommendations, it will focus the minds, let's say, of the people who want to try and negotiate with the current owner.
Jane?
I just wondering if any other member, I'm just going to make the point that it's about what we are trying to achieve with our policies, which is retention of community facilities. I would suggest to members that you've got to have a willing seller as well as a willing buyer. And if the seller, who is quite clearly and perfectly legitimately driven by money issues, then obviously that interest will take precedence over an attempt by a community group to buy a pub.
Oh, sorry.
Yeah, I mean, I think this this power of veto over planning applications is shaky ground. I'm aware there's facilities that communities use, and there's a community facility. A lot of the time, we would understand that to be a sports centre or a library or something that's actually a sort of public asset. This is a private undertaking, and I'm very uncomfortable about. I wasn't comfortable with the decision last time, and I think my position is still the same.
Right. Proposal for second. Yep.
I have a motion put forward by Councillor Hislop and seconded by Councillor Crothers to go with the recommendations as per the report to approve subject to conditions. And I have an amendment by Councillor Maitland and seconded by Councillor Dick to refuse the application on the basis that the reuse of existing community facilities, and that it has not been satisfactorily demonstrated that all other options and possibilities have been explored and exhausted.
So just to clarify, that's in respect of application A, and application B, you're satisfied to go forward with the recommended approval. Okay.
Chairman, can I be quite clear that I also preface those remarks by saying these proposals are contrary to local development policy CF1B.
That's noted. Councillor Martin?
Amendment.
Councillor Dempster?
Motion.
Councillor Crothers?
Sorry, Chairman, could you remind me what the motion amendment was? Apologies.
That was my point as well, Chair, if I could, because are we voting on the two separate things? Because the motion and amendment affects the first part of the application, not the second.
Jane's amendment. The amendment.
Yeah, okay, that's what I'm getting at, yes.
To agree part B, which was the historic building.
Okay, that's fine, that's it.
I think that's generally been agreed to go with that.
Okay, motion put forward by Councillor Hislop and seconded by Councillor Crothers is to go with the recommendations as per the report, and the amendment put forward by Councillor Maitland and seconded by Councillor Dick is to agree Part B, which is the listed building consent, and refuse on the basis that the reuse of existing, that these proposals are contrary to local development policy CF1B and the reuse of existing community facilities, in that it has not been satisfactorily demonstrated that all other options and possibilities have been explored and exhausted. I'll just start from the beginning. Councillor Martin?
Amendment.
Councillor Dempster?
Motion.
Councillor Crothers,
Motion.
Councillor Dick,
Amendment.
Councillor Drybrough,
Motion.
Councillor Ferguson,
Motion.
Councillor Geddes,
Motion.
Councillor Hislop,
Motion.
Councillor Maitland,
Amendment.
Councillor McCoughtry,
Amendment.
Councillor McComb,
Amendment.
Councillor McKee,
Motion.
Councillor Syme,
Motion.
Councillor Thompson,
Motion.
and I can confirm that the motion carries and the decision is to go with the recommendations as per the officer's report.
It's nearly 12:30. I think we'll take a break for lunch and back here at 1 o'clock. As I've declared an interest in item 7, I'll vacate the chair for Jim.
Good afternoon, members. We come to agenda item number 7. Non-compliance with condition 2, that no caravan shall be occupied as sole or main residence of planning permission 16/P/3/00004 to allow the use of 6 caravans for permanent residential use. Change of use and alterations to dwelling house to form 2 holiday flats with public bar and games room on the ground floor, resiting of 1 static caravan, hardstanding, and removal of 1 static caravan, hardstanding at Mouswald Caravan Park, Mouswald Place, Dumfries. This is a full application. The reference number is 16/1799/pool. The recommendation is to refuse. Case officer is Carla McWhinney, but taking us through the presentation today is Pat Hanna. Pat, will you just take us through your presentation, please?
Thank you, Chair. Just a bit of background to this site. This is a long-established holiday caravan site, and planning permission was subsequently granted in 1998 for the use of 15 caravans as residential park homes, which means that they're suitable for permanent residential use. Use of further holiday caravans for permanent residential use has been refused twice by this committee in 2013 and in 2015 on the grounds that council policy now states that caravans are not suitable for permanent residential use. In 2016, planning permission was granted under delegated powers to remove the original condition restricting occupancy between March and October only, and bringing the condition into line with current standard, namely that no caravan shall be occupied as the sole or main resident of the occupant. Just running through some of the slides. This is the location plan. The site is accessed through a private access track between a cluster of dwelling houses on either side. The site itself comprises Mouswald Place Mansion House, which is an unlisted but quite significant traditional building within the centre of the site. The existing block plan shows the mansion house within the centre of the site, and immediately southwest of that, a couple of holiday cottages. To the southeast, in brown, you can see the residential park homes, which are permanent residences. The white hard standings are touring and static holiday units.
The proposal is to change the use of the mansion house to 2 holiday flats and incorporate leisure facilities as shown hashed on the building there. That's the first element of the proposal. The second element of the proposal is to remove one of the existing holiday units, which just to the north of where the access comes into the site. I'll flip backwards and forwards so that you can see 2 hard standings are being replaced by 1. And finally, that 6 of the existing holiday caravans be occupied for permanent residential use, as shown, changing into brown there. This is the internal layout of the mansion house, showing on the ground floor, on the left-hand side, a flat that can accommodate 6 to 8 residents with leisure facilities shown in green. And on the right-hand side, the first floor plan shows a holiday flat to accommodate 10, 12 plus people. This is a view along the access looking back towards the public road and turning around, looking down the access road into the caravan park itself. This is the southwest elevation of the mansion house, and the leisure facilities are to be within the ground floor section of the mansion house that is directly in front of you, using the 3 big main windows that you can see on the ground floor there. Another view of the mansion house. These are the typical residential pitches, and these are the typical holiday pitches. And this is the proposed site of the residential park homes. Notwithstanding that there's an existing historical residential park home use on the site, the council's current policies consider that caravans are not suitable for permanent residential use. And this position is reflected in policies as set out in paragraph 4.4 of the report, where it says that policy ED10, which relates to tourism, there will be a presumption against tourist accommodation being used for permanent residences. And under policy H7, which relates to temporary residential accommodation, the council will not normally support proposals for the change of use of caravans, chalets, or other temporary structures to houses. As I've said before, that element of the proposal has been refused twice by this committee before, and the current recommendation remains a refusal. Thanks, Chair.
Thank you, Pat. Any member, any questions for the case officer? Ian.
I suppose just a small one. I don't think it's a planning matter as it's been described within the report, Chairman, but I think there's ambiguity over the ownership of a piece of land. I'm just interested to see where that was, Pat, that's all.
Excuse me, Pat.
Thanks, Chair. I've got some photographs that can show that. The disputed area of access is just to the right-hand side of the access, as you see here. And if I flip around, I have got an additional photograph that shows the disputed access itself. The bell mouth that you can see in the photograph there, lined with the plant pots, is the disputed area. Just to clarify, though, that is a civil matter between the parties.
And that was reflected in the report, and I'm sure you know that, Ian. Hey, Jane.
It's okay. I found the answer to my own question.
Okay. If there are no other questions for the case officer, we have one speaker. We have Mr. Alec McKechnie. Alec is also reading prepared statements for 7 objectors, so we have a total of 24 minutes. So I will do your 3 minutes first, Alec, either just a verbal presentation of your letter, and then if you want, you just go on to the other objectors. You have 24 minutes. If you want to make it shorter than that, I'm sure the committee would appreciate it. Just come forward, Alec, and use the microphone, please. There's a wee button to the right, just below the microphone. Just pop that on, please.
Thank you.
It will be shorter than that, and if you don't mind, I would like to leave mine till last. I'll start with some of the others.
It's absolutely fine. We'll just, whenever you're ready, Alec, we'll just keep you in mind of the time. Thank you.
Thank you very much. First letter's from Linda McKechnie, Woodgrove, Mouswald Place. I am the owner of a neighbouring property which has a boundary with Mouswald Lodge Park, and I object to the planning application on the following grounds. The owners state that they have installed 6 lodges with hot tubs and raised terraces in February 2016, and now are installing 6 more. No planning permission for raised terraces and hot tubs with sound and lighting systems has been granted previously. As these are commercially used, they should not be considered under the permitted development rules. The owners also state that the Lodge Park is within the village of Mouswald. This is not the case. The park is out with the village by 1 mile and is in the countryside, as all Border Caravans publicity material states. So this cannot comply with the policy H2 housing development in villages and local development plan. So therefore, policy H3 housing in the countryside should apply. The Lodge Park is situated in the hamlet of Mouswald Place, comprising of 8 houses, a recognised hamlet, not a village. The Lodge has more units. The Lodge Park has more units in total, with residential and holiday lodges, than the whole of the village of Mouswald and the surrounding area. This application also continually refers to caravans. Mouswald Lodge Park does not have any static caravans. All units are lodge homes. A static caravan is 12 feet by 28 feet. A standard static caravan is 12 feet by 28 feet. These lodges are more akin to the size of 2-bedroom bungalows, as the majority are twin units, twice the size of a static caravan, and all have pitched roofs, making them higher in profile from front and side. The Lodge Park and neighbouring houses are served by a single-track road with passing places from both the A75 and Mouswald Village. The rise in the number of vehicles from the Lodge Park's development already has resulted in much more traffic, and any further development would only add to the problems that are already being created. Homes in Mouswald Place already suffer from low water pressure at peak times, and further development in the Lodge Park would only increase this problem. As the lodges are classed as mobile homes, they do not need proper soakaways for surface water, and the result, properties and farmland around the Lodge Park suffer from surface water runoff from the park. The sewage system runoff outlet into Clough Burn continually smells foul, and solids particles are frequently seen in the burn at the outlet. I will be contacting SEPA regarding this, as it would appear that the system is unable to cope with the development at the moment, and any increase in residential occupation at the park could only worsen the situation. In addition to the specific issues I have raised,
30 seconds to go on this first one, Alec.
I find it difficult to comprehend how an individual or a company can basically build a small village in the countryside, as this is what I feel has happened, and I strongly object to this development becoming even larger and more populated.
Thanks very much, Alec. Just bang on 3 minutes. That's the first one.
Excuse me. The second is from Angus Irvin, Greenacre, Mouswald Place. I object to the planning application by Mouswald Lodge Park. As intimated to you on a previous objection to an application from the park, I noted in a letter to the planning department that I was intending to reclaim the corner at the top of the access lane to the park, so that it was in keeping with the deeds, my title deeds for my property. On the 28th of December 2016, a fence was erected on my boundary to bring this to fruition. On the 30th of December, this fence was smashed to pieces by Mr. Weatherly's employees. This issue is now with my solicitor, and I would normally make no further comment. But, as the Roads Department's no issue with the planning application states, it may have to reconsider if proved that the park does not control this piece of ground. I would wish to make the following points. I would like to inform the committee that my solicitor has copies of every land disposition for my property and grounds since 1965, none of which show this piece of land belonging to any other person than my property land deeds. We also have the land register title deeds plan for the Lodge Park, which shows they do not own this piece of ground. This week, my solicitor has obtained a statement from Mr. Stan Walker, who previously owned the caravan park, and he has confirmed that we had an agreement to allow him to use this piece of land, and the park did not own it. He has also confirmed the dates that this agreement took place, which proves it does not qualify for a servitude right of access under Scottish law. These documents are recorded proof of events and are available to the roads and planning departments if required.
Thanks very much, Alex. Second one, okay. Come to the third one.
Third one's Tom Beattie, The Orchard, Mouswald. As a neighbour of Mouswald Lodge Park, I object to this planning application from Mr Brian Weatherly. I have lived here for over 35 years. When this small site was only for touring caravans, it was passable. Now it is overcrowded with plastic-clad lodges. This person has caused nothing but trouble since he came to the area. The site has residential units and holiday lets. Some of the holiday lets have people staying in them on a residential basis, breaching existing planning permissions. The number of lodges is way too much for such a small area. This causes major problems on the restricted U-class road, of which passing places are virtually non-existent, mostly of a field gate entrance, which are now deep mud holes. The verges and draining ditches at my house entrance have been flattened by huge low-loader vehicles entering and leaving the park. These are not suitable for such a small roadway. They also take it in their own hands to cut away private areas of trees and hedges belonging to local residents to accommodate the movement of lodges. Excuse me. I have a retired police inspector next to me who has had nothing but trouble from the park regarding a property boundary dispute which has been very stressful for him. I am very surprised from my own planning experiences that this small area has been allowed to expand to the size it is now. And as for any further planning applications for this site, they should be refused, as the similar applications have been refused in the past and the holiday lets checked for misuse as residential homes.
Thanks, Alex. That's another one. Thank you.
Do you mind if I take a drink? Mr and Mrs Forsyth, North Lodge, Mouswald Place, Mouswald. We have lived as neighbours to Mouswald Place Caravan Park for over 20 years, and not once in those 20 years have we made any objections to planned improvements by previous owners, or have felt the need to complain about the behaviour of those using the facilities on site, until now. Following formal submission of our objections in January 2016 to the current planning application by the owner of Mouswald Place, I am authorising our neighbour Mr Allen McKechnie to speak on our behalf and ensure the planning committee are aware of all the major issues. The detail is aforementioned document lodged with the council, but is summarised as follows. 1. Breach of planning. The applicant has already completed the groundworks and located lodges linked to the application in advance of and in breach of planning approval. Breach of planning. 2. The applicant is allowing permanent residency in lodges which are marked for holiday letting. This has already been flagged up to Dumfries and Galloway Council previously without action. 3. Human capacity. Mouswald Place is a hamlet with 9 permanent owner-occupied homes, with infrastructure to support this level of occupancy, with resources such as water, digital and roads already under strain. This application would lead to an additional 90 people on site at any one time. This is the equivalent of establishing 20 two-bedroom bungalows, which is absurd. Point 4. Infrastructure. Water. As we are at the end of the water pipe, we are continually experiencing issues with water pressure affecting both our boiler, showers and other appliances in our property. Yet again, a shower has broken due to the fluctuations in water pressure only this week. Infrastructure. Roads. Already at capacity, the single track lane we live on is nearing danger levels. There is potential with this development to be in excess of 63 vehicles at any given time travelling on and off a danger stretch onto the A75, in addition to the current residents in the surrounding domestic properties. The road verges are being churned up, potholes are appearing, and passing places are unable to cope with this level of traffic, never mind danger to humans and animals walking. Wastewater. As per my detailed submission to the park owners do not have the capacity for the current, never mind future growth of the site, and are discharging into the local burn and neighbouring fields, including wastewater from hot tubs, which we can witness from our kitchen window being discharged into neighbouring fields owned by Cloughbray Farm. Noise pollution. Noise level over the winter of parties of stag, hen and young people have been unacceptable, and as the spring season approaches, we anticipate having to make further formal complaints to the park owners and ultimately the police, as there seems to be no policy respecting local working people and or guidance on the use of external sound systems on each lodge, which I cannot believe have planning consent. We have never been bothered by noise in all our 21 years as neighbours. These are my main areas of objection, but I could also cite light pollution, rubbish pollution, major problems with telecoms infrastructure affecting our ability to work from home. As such, I strongly object to any further development of this site, would recommend a site visit by council officials and planning executives for future planning applications. I would happily take this matter further if required, but would hope that the committee would recognise the council's planning executive's recommendation and refuse this application.
Thanks, I like that. Yeah. Next one, please.
Jai D. McKechnie, The Beaches, Mouswald Place. I am writing to object to this planning application. I own a property in Mouswald Place in close proximity to Mouswald Lodge Park. I do not feel that any further development of this lodge park should be allowed, as the existing park has already created a lot of problems with increased traffic on this small country road. This is not only an increase in cars from the residents of the lodges and visitors to the holiday lodges, but also service vehicles, including delivery lorries, vans and taxis. I have also noticed that there is continually a lot of rubbish, such as takeaway containers and drinks cans lying on the verges and roads, which I can only assume comes from Lodge Park traffic, as it was never a problem before in the 17 years I have lived here. There's also an increased problem with dog fouling since the Lodge Park increased in size and have installed holiday lodges. I have also had recently issues with increased noise from the park and have had cars and pedestrians in my drive looking for the Lodge Park. I also object to my driveway entry area, which I had to construct and maintain at my own expense to satisfy road planning conditions, being used as a passing place and lay-by by the increased traffic. This has also caused me stress and anguish by wondering who and what vans and cars are doing parked at my gates, as I am an 85-year-old pensioner living alone. The Lodge Park has been refused planning permission before, so I feel that this application should also be refused. The population of the Lodge Park is already too big, and they should not be allowed to increase any further, as this is a quiet countryside location.
Thanks, Alec. Next one, please.
Patricia Beattie, The Orchard, Mouswald. I am writing to object to this planning application. The caravan park at the moment is causing excess vehicles on a minor road. You should have a site visit to appreciate the problem. We also have excess footfall with dog owners who do not clear up the dog's mess. Mr. Weatherly, the park owner, does not live in the community and has done nothing to support our local community. Instead, he has only caused us problems. He is already ignoring your rules by having permanent people living in lodges. How is this allowed? Mr. Weatherly appears to totally ignore any rules except his own. As a neighbour, I also object to a bar on the site which would lead to more strangers roaming around. Similar previous planning applications from the site have been refused, and I would hope the Planning Committee will follow the planner's findings and recommendations and refuse this application.
Thanks, Alec.
This one's mine.
I think now you've made your presentations, members can ask you questions on them, although there are certainly a lot of numbers that have been matters that have been raised, but they can ask you questions on whatever your observations are.
Yep. Okay. I have lived next to Mouswald Caravan Park for 19 years without any issues until the current owners took over. Although previous similar planning applications have been refused, the site has continued to expand. The removal of all static and touring caravans, which have been replaced by large bungalow-type lodges, has changed the character of the site from a country caravan park to a small town. I agree with the environmental and infrastructure problems raised by my neighbours and other objectors regarding unsuitable roads, traffic increase, waste and surface water problems, and general littering. In fact, myself and my neighbours, and Dave Muir of Cliffbrae Farm, have all picked up bottles, cans and general rubbish, filled bags with it actually, thrown over the fences and hedges from the park into our gardens and land. This further highlighting the disregard for neighbouring properties and people shown by the park owners. Several questions regarding the breach of existing planning and site licence conditions were raised in the objections submitted to the planning team. These are being investigated by the planning enforcement officer, and he has this week informed us that he has visited the site last Thursday, and he will be contacting the owners regarding one lack of consent for structures, and contacting the council environmental officer responsible for the site operating licence conditions regarding another 2 issues. I would therefore ask that, given the planning officer's recommendation for refusal on the grounds of planning policy, the objections raised by neighbours of the park and objections raised by park residents, and the fact that there was absolutely no letters of support for this moving forward, and appreciating the ongoing planning enforcements that are taking place, that this application be refused by the committee.
Thanks, Alec. Thanks very much. And if you just sit with us a minute in case any members have any questions. Would any members have any questions for Mr McKechnie? Ivor?
There's a lot of information there that you've given us. In your presentation, your last one, did you mention that there was evidence that currently there was permanent residence taking place in the static caravans? And what sort of evidence have you got of that?
There's been permanent residency in caravans that are for holiday lets for about 3 years. You can ask the postman. He'll show you where he delivers the letters. My boundary fence is straight across the park, and it would take a blind man to work out that 5 guys getting into a van in the morning to go and work at the hospital with yellow jackets on are on their holidays, subsequently enjoying the area. There's people been living in there, as I say, for 3 years. The park previously applied under an enforcement order to extend the holiday use from 8 months to 12 months, because Mr Weatherly was under the impression that that would then give him the ability to be able to use them on a 12-month basis, because he knew he was flouting his consent and he had no choice but apply for the 12 months. He applied for the 12 months and he got it because the planning department chose to take the objections as per household and as not per objection. There was 8 objections, so it didn't come to committee because they took it as less than 6 because it was household. They chose, apparently they can choose to take it that way. So he got his 12 months. The conditions on his 12 months that they cannot be a sole or primary residence, he still doesn't accept that fact. If you go down to that park and you say that you want to live there, or you want to take one on, or you want to buy it for a home, he'll tell you that he'll say you can do that. He's not accepting on his terms of his licence. That's the second, one of the 2 points that the enforcement officer is talking to the officer regarding the conditions of the site licence, because that's a site licensing condition, and he's pursuing that with the relevant person before he puts a letter forward. There's indisputable evidence.
Thanks, Ivor. Any other members for the objector? In that case, Mr McKechnie, will you take your seat again, please?
Thank you.
Very grateful. Tracy, can you switch off the mic, please?
Sorry,
No, it's all right, Alec. Tracy will get it. Members, we're now in session. Ian, Tom, and then Archie, and then Alistair.
Thanks, Chairman. I think it's fair enough just to move the recommendations to refuse as per outlined within the report itself.
Thanks, Ian.
Happy second.
Tom, I've got Archie, Alistair, and then I appear to have Ivor, Stephen, and Ian.
I would agree with what's going on, Chair, but I mean, I think there's an issue here that planning conditions are not being met, and the planning enforcement officer is doing his job to try and get, some form of movement. It's maybe not a planning issue, but it's one of these issues that come up occasionally on planning committee, and I think that if they are not abiding by their conditions, then the council shouldn't be scared to take them to court and get the planning application sorted out.
I'm sure David will have been very busy, as will Pat, noting down the objections and the observations, but we're here to deal with planning application, no breach of conditions. But you're right, Archie, and I'm sure our staff will deal with that. I've got Alistair, Ivor, Stephen, and Ian.
Merely to say, Chair, that I wouldn't demur in any way with what's already been said. Just let's get on with it and proceed as accords.
Thanks, Alistair. Ivor?
Chair, it was just to sort of echo the comments of Councillor Driver that if there's something going on here, I hope it's being dealt with, and if it needs to come back with a report for non-compliance, then hopefully that'll be brought at an early time.
I'm sure process will be, or due process will be conducted. I've got Stephen, Ian, and then Jane wants to say something as well.
Thank you, thank you, Chair. No, I mean, I'm just repeating what's been said already, but I think in terms of the issues raised about non-compliance with existing permissions, are we able to, is there any information we can get, given that this has been presented by the representative, in terms of what the planning authority actually knows is being carried out to address these reported concerns?
That's something that you can source at a different date. We're here to deal with this planning application. Members of our staff will be delighted to assist you and give you the information that you need. Ian and then Jane. Ian, you know what in now? Okay, that's fine. Jane, last word to you.
Well, it's just a question. I thought I'd found the answer, but in fact I haven't. It's the fact that the report suggests that half of this planning application is actually acceptable. I mean, that's what the report says. The report says 4.6. The principle of conversion of the existing dwelling house of 2 holiday flats and alterations to reinstate the public bar and games room is considered acceptable.
I think we'll not be able to split it though. We have a full application. We have to determine the application as before us. An officer recommendation is to refuse. That's not to say that they couldn't have come back with half that you've identified.
Sorry.
David wants to help you, Jane.
Yes, thank you.
Yes, basically that is correct. You can't part approve, part refuse an application. You've got to deal with it as an entity. And there are elements of this application which, were they to be submitted as a freestanding application, would comply with policy and would be acceptable. But because they've chosen to put in the application in the manner they have, we've no option but to refuse the whole lot. But it's quite clear in the recommendation what the grounds of refusal are.
May I come back just to ask?
Sure thing, Jane.
That's absolutely fine, and I have no difficulty with the way that other members are going with this, let me tell you. But if the planning applicant was to appeal, would the appeal say, oh, well, actually, half of it was acceptable and you said so? You know, I just want to be absolutely clear that we're not going to open ourselves to something which we don't want to achieve.
I'll let David come back in, but again, we make a decision based on the information we have, and if somebody wants to appeal, that's their absolute right, and it's Scottish Government's right to overturn or overrule the decision we make. But I do stand by what we've said, or what members are saying, that we decide.
Chair, yes, basically where you have an appeal, the reporter would be looking at it on exactly the same basis that you are today. In other words, it's one application, it's one entity. Parts might be acceptable, but the overall proposal isn't acceptable because it involves something which is clearly contrary to policy. So no reporter could approve the bits that might be acceptable.
I'm sure, Jane, like me, you wouldn't want to start speculating about what somebody else would say and decide on that basis. It's a professional judgment we make. So we have a motion from Ian, seconded by Tom, to go with the Office of Recommendation and refuse this application. Do we have any alternative proposals? Lucy, can you confirm the decision of the committee, please?
I can confirm that the decision of the committee in relation to item 7 is to go with the recommendation as per the report, and that's to refuse the application.
Yeah, can I come in just in a way? It's on a. I'm looking at the delegations for this committee and everything else, and there's a bit there when the gentleman's away, because he manfully ploughed himself through 7 different letters, but almost everything was exactly the same as the one before. And the guidance we've got in here is that there should be strongly recommended that parties should group together and use a spokesperson to make a collective presentation, because that could have been one collective presentation in 3 minutes. I don't know if that was tried or not, because it was quite painful sitting through 7 saying all exactly the same thing. So is there a way we can make sure that offer is put to them?
I'll ask David to confirm whether or not that happened, but we have to remember that this is the only opportunity people have to have their views expressed. And if they want it done individually, I'm sure neither you and I would want to stop that. But David, can you advise Andy what happened in that case?
Well, what's happened in this case is you have a number of individual representatives who, for one reason or another, weren't able to attend, and they are entitled to ask a proxy to read out a prepared statement. What we did do was we changed it to that. If you remember, there was an instance at Cross Michael a while ago where one individual took people who couldn't attend minutes and had 24 minutes for herself. Now that clearly wasn't acceptable and we did make a change, but if somebody is unable to attend and they've put in an individual representation, the way it's structured, they are entitled to ask for a proxy to read it out. So that complies, I'm afraid, what they've done. The only alternative would be to really change the public speaking rules, but I think we've been through that one in the past and members seem quite happy with what we have in general.
I think what I'm saying here is we could maybe have convinced them to put something in.
Go to item 8 in the agenda, Lethans Wind Farm, 5 kilometres north-east of New Cumnock. It's a consultation regarding an application made under section 36 of the Electricity Act 1989 for the erection of 22 wind turbines and associated infrastructure on land falling within the East Ayrshire Council area, 16/C/2/0017. And we've got Andrew Robinson speaking for this one. Just whenever you're ready, Andrew.
Okay, thank you, Chair. Yeah, this is the council's been reconsulted on this application by the Energy Consent Unit. This is an amended scheme that's been put in the East Ayrshire Council area. This council previously objected to that previous layout that was put before you. The details of that are in paragraph 1.6, and it's been amended, and we've now been reconsulted on those amendments. So the application site is situated in an area of forestry immediately to the north of the Dumfries and Galloway Council area, on the northwest Lowther Hills, just northwest of Kirkconnell, and it's pretty much the southern tip of the site, bounds the Dumfries and Galloway Council area. And the site is set back from the Glenmuckclick surface coal mine, just to give an idea of what's in the surrounding locality. So this is the proposed site layout. I'll just quickly run through what it is because it's a bit difficult to see on the slide. But access is proposed from the west, which is actually within the East Ayrshire Council area. There's 22 wind turbines proposed of varying heights, which I'll show you on the next slide. But they're also described in paragraph 1.3. And there's 4 turbines that are closest to the boundary. And these are the proposed turbine heights. There's actually 3 different heights proposed. Those highlighted in blue are 136 metres in height, so those are the ones closest to the boundary, and there's 1 or 2 setback as well. Those in red are 152 metres, and those illustrated in green are 176 metres. There's a met mast shown on there as well, but that's actually been removed since this plan was submitted. And the previously proposed turbine heights, those previously proposed to be 26 wind turbines with heights varying from 136 metres identified in blue, and those in red are 152 metres. This is probably the easiest one to show the comparison between the 2 schemes. So this, which one's the pointer? Oop. Basically, there's 5 turbines at the bottom left there which have been removed from the scheme, and there's been an additional turbine put in at sort of in the middle of the scheme at the back. So effectively, there's been a net reduction of 4. Which one is it? Is it? There we go. Right, so these are the 5 that have been removed, and that one's the additional one that's been put in. As a result of some of the turbines being over 150 metres in height, there's a requirement for them to have aviation lighting added to them. So that's been shown in red, but the turbines closest to this council area do not have that on them. In terms of visibility, this just shows the hub height ZTV. So in yellow is 1 to 5 turbines would be potentially visible. In blue, that's 6 to 11 turbines. Red is 12 to 16 turbines, and in green is potentially 17 to 22 turbines visible. And if we go to the tip height, the majority of that is actually shown in green, so it's showing potential visibility of 22 turbines from Kirkconnell and Sanka. And this just shows the distribution of community wind farms with green operational, orange approved, red in planning and purple in scoping. I'll just go through the viewpoints that really affect this council area, starting with viewpoint 17. This is taken on the A76 closest to the East Ayrshire border, really. On the Y line drawn in the centre there, it's the blue turbines that represent the Lethans proposal, which is before you, and the red turbines are actually the Glenmucklock scheme, which was recommended for approval by this council not too long ago. This the way that the submission has been put in is the photo montage has effectively been split in two. So from the previous photograph, this is effectively showing the left part of that. So you can see just the tip of one of the turbines just there. And then going to the right-hand side, you can see some more. Appreciate it's slightly difficult, but that's the cluster there. But that shows the comparison with the Glenmucklock scheme, if both were to be implemented. This is viewpoint 18, just west on the A76. So again, it's looking north. You can see Glenmucklock surface coal mine just here. Again, this is the left part of the photograph, and this is the right part of the photograph. Now, I don't know how this is going to come out. Part of the further environment information process, the applicant was asked to submit night visuals, which is quite a new thing, because of the aviation lighting. Now, there will be one or two turbines where you can see the red light. It's fortunately not come out very well. There's one there. It's effectively the turbines that are set further back. So just on the ridge line, you would see one or two turbines with red aviation lighting. The game hasn't really come out. But, okay. Right, this is viewpoint 90. There was a part of the previous council objection was as a result of impact from this archaeological setting, on this archaeological feature, sorry. As a result of the amended scheme, the archaeologist does not think that it's of significance to sustain an objection, although does recommend that turbine 12, which is the third one in, is that one. It would actually, if that turbine was to be removed from the scheme, it would lessen the impact on this setting further. So this is what you would see from this feature, along with Glenmucklock, and this one slide as well. And the final view, there's this is taken from an access road leading up to forestry tracks to the south side of the valley. So again, you can see that's the left-hand part. That's the turbines just there. And then the remainder there. And this is taken from Todd Hill's Mast, which isn't too far away from the application site, so it's looking west. Again, you can see the turbines. And that one as well. And okay, this is the final one. This is from the Southern Upland Way to the southeast of the site. So that's those red turbines in the foreground are actually Ulsyside Wind Farm, but the site would be further in the distance. So in conclusion, it's considered that the amendments to the scheme, along with the change in the baseline position with regard to community wind farm development in the area, has reduced the adverse effects of this scheme to serious effects on Dumfries and Galloway Council. And it is considered that the removal of turbine 12 would further reduce the impacts on that archaeological feature, but it is recommended that no objection is raised to this scheme.
Members, Alistair.
Thanks very much indeed, Chair. It's in relation to paragraph on page 81, sir, talking about aviation lighting. Assuming, and I I appreciate that may be something of a bold assumption at this particular stage in the process. But assuming that we do adopt the recommendation to raise no objection, I take it would be competent to perhaps draw their attention to the fact that they should be considering doing, what we do down here, and instead of having the red lighting, make it infrared. Because if that's competent, I would suggest that at the appropriate time, we should certainly be considering that.
David?
Unfortunately, it's a civil aviation requirement that anything over 150 metres actually must have, it's usually a flashing intermittent red light, and that trumps any planning requirements. I'm afraid it would be a CAA requirement.
Yeah. Jim?
Thanks, Chair. I'm looking at 411, page 86, and seeking clarification on the opening statement. Whilst it is considered that the development in isolation would give rise to some significant effects, cumulatively, in addition to Glenmuckler, these effects are reduced. Andrew, could you please explain that statement to me?
Yeah, basically, it's probably best to refer back to the landscape architect's comments in section 2.2. Effectively, it's considered by the landscape architect that the Lethans scheme, along with Glenmuckler, it would actually consolidate wind farm development, because in isolation, if the Glenmuckler scheme wasn't to be there, this would be moving wind turbine development onto this side of the valley. But because there's already, it's not consented yet, but it is minded to approve, because there's the Glenmuckler scheme that's being proposed there and is minded to approve, the turbines together would actually, it wouldn't be so prominent on the top of the hill. That was the key issue. Before the Glenmuckler scheme, this would have been a scheme viewed on a ridge line and viewing quite prominently. But because of the Glenmuckler scheme, it's considered that wouldn't be so significant.
Chair, Jim. Are you saying, Andrew, that there will now be so many turbines that you won't actually notice the ones which are at the back? Is that what it amounts to saying? Thank you.
You got in one, Jim. Thanks, Chair. Just like to say, I liked the first map that come up today, because it's a long while since I've seen a council map with Kirkconnell on it. It's usually got Sanker and then the Cumnock and Mere missed out in between, so it's nice to see that. I'm speaking on behalf of Kirkconnell Community Council now. The developers here was in touch with them about a year ago, had a bit of contact with them. As you know, we had a major problem with community councils being disbanded, and I think they've kind of lost their way a bit. They're really concerned about this and about the East Ayrshire applications. We noticed there that one of the sites included was Hare Hill. Recently, Hare Hill had an extension, and the new turbines that are in are more visible than the original ones, and we never had any contact with the company telling us that this is a different company, but we're frightened that the same thing happens here, that, you know, we're agreeing to all these things, and then East Ayrshire has a sort of will of their own. So one thing I'd like to ask as a condition today is that you do contact Kirkconnell Community Council, and I think also Sanker Community Council, to discuss the effects of this new wind farm, because as I was saying earlier, I mean, I can imagine boys coming out the pub on Saturday night and see all these lights. It's got to be like Blackpool Illuminations when you see what they've got earmarked there. There is a lot of things to consider, and it's too late once these things are up. And I'd also like to say to you, I take it that myself and Councillor Dempster have experience of these things going in, and they don't really estimate the amount of upheaval with roads going in and different things as well. I'm sure they'd like to ask questions about that. Is anything going in from our side? A lot of things happen, and I think it's really important to engage with
community council, because there's a lot of new community council members since they had dialogue with the developers before. So would that be pertinent to put something in like that?
Depends on how we could certainly raise it in our letter back to the Energy Consent Unit. This application, I understand, East Ayrshire Council will be considering this at their committee. I think it's next week. So our response will go back to the Energy Consent Unit. I don't know whereabouts in the process of how the applicant can actually engage with the Community Council now in terms of how far it is down the line. But I don't see any harm in us as a council putting statement in to encourage the developer to maintain dialogue with the community councils. That's something that members want us to include.
Way back in, John.
Just quickly, Chair, because I mean, if you look at the proximity there, we're going to be more affected than many parts of New Cumnock and the East Ayrshire side. So I think it's a bit unfair, at least not to have some dialogue with the local community councils.
Thanks, Chair. And
Robert, come in on that.
Chair, it was something that came up last July at the Ben Brack Wind Farm Public Local Inquiry, which again, it's on the A713 corridor, if you like. So it's north of Carsfern, so Carsfern Community Council were the affected one, not Kirkconnell or Sanker in that case. But again, it was raising cross-boundary issues with East Ayrshire Council, and at that PLI, the reporter was keen to establish the relevant community councils on both sides of the boundary so that the applicant and the developer could make contact with them in respect of community benefits, should they be minded to grant consent for that scheme. So I think, again, as Andrew says, what we can do at this stage, certainly in the consultation response, if members are willing, is flag up the community council interest on the Dumfries and Galloway side, and just make it clear that there's an expectation that there'll be further dialogue with those community councils, in respect of community benefit and a range of other issues, if that's what the members are looking for.
Thank you, Robert. Jim?
Thanks, Chair. Firstly, I would have thought community councils were statutory consultees, and I would have thought since we were consulted, we would have cascaded that down to them, irrespective of the fact that it's not actually in the Dumfries and Galloway Council area. But anyway, that's maybe for another day. The other thing is, and maybe being a bit pedantic, but Andrew talked about Yellowside Wind Farm. Yellowside Wind Farm, the application is not even in yet. Whiteside Wind Farm is up, and that's a problem we've got. There are so many constructed in the offing that we will finish up in a situation where we'll not can see what's the off phraseology, you can't see the wood for the trees. And I don't particularly like, and it's no reflection of Andrew's opinion, but I don't particularly like the approach that if a few more no metre, we saw an application for 78 houses in the old college site. We should maybe double it up to 186, because if there's a few and a few more no metre, well, actually it will metre. And lastly, we have a landscape architect, and the landscape architect, when Sanker Wind Farm was consented, that said Drumboy Farm. In the documents, they've actually kept it for future reference. It said in it, should this wind farm be consented, we will have reached saturation point. And it seems that we reach saturation point, but then we just go on and on and on. And it concerns me that we're no having a situation or a holding position where we deem that in reality and in fairness to the community that John represents, sometimes enough is enough. And personally, I wouldn't support it, not because of anything that Andrew has said, but just simply because Upper Nithsdale now is an absolute a magnet for extensions on existing wind farms and additional wind farms. There's no landowner, as far as the eye can see, for Kirkconnell or Sanker, that hasn't made application or in the process of making application to install wind farms. And whilst it supports the green energy concept and energy generation, there has to be consideration given to the people that live and actually try and establish a community and maintain the social fabric of communities. And sometimes these constructions just don't help.
Maybe want to respond to that? No.
Okay. What can I say?
Fine, that's
Yeah,
fine, David.
I'll probably better not start on that one, but yes, obviously, you've had the likes of Sandy now and Glenmucklock Wind Farm, which is officers, we would agree with that view. But given the approval or the indicated approval of Glenmucklock, that has material changed the circumstance where the landscape is now a landscape with wind turbines, and this one adjoining, therefore, isn't going to have the same effect. And that's really the point Councillor McComb was raising. It's cumulatively the landscape character has changed, and we have to accept that.
Thank you. Andy?
Thanks very much. Kind of a technical question, because this is our consultation, and Jim touched on the community councils are consultees in their own right. So the question is, why would we be putting the view of a community council without any representative or mandate from that community council to do so? I don't disbelieve John's been speaking to them. Don't take that wrong way, John. But if we deal this as we should, we make a decision as a council what we think, and the community council should be making their own representation, would be my view as a technical thing in this.
David?
That is correct. We have, as a council, are a consultee, and therefore actually have the same status as any community council with this one. We've been consulted by the Scottish Government and had to feed back to them. We're not the determining body. Accordingly, they wouldn't be consulted in the same way as if there was a planning application, where we definitely would put that out to all community councils.
Ian?
Yeah, just again clarification on that. It says at the beginning of the papers there, members are asked to raise no objections to consultation. Does that mean it's still going to consultation? Or, as the planning officer said, it may be go for the planning committee in East Ayrshire next week. So what are we raising no objections to?
Well, we as a council have been consulted by the Scottish Government. You probably add an extra word in there just to make it clear it's no objection to the consultation from the Scottish Government. But there'll be a number of parties who have been consulted by the Scottish Government, because this is under the Electricity Act, not the Planning Act. And East Ayrshire are similarly only a consultee. So the primary consultee with this one, if you like, is East Ayrshire Council, because it falls within their area. Because of the proximity to us, we've been consulted as well. But it is just our response as a council to the Scottish Government, who will then consider the application that's with them under the energy consent.
So just to be absolutely clear, this is so that we agree to let the Scottish Government consult.
Well, the Scottish Government have consulted us. This is our response back to the Scottish Government.
Remember? Go on in.
This is just a throwaway line, members. It's nothing to do with this application per se. But we're just about being told by Andrew and David, don't approve the first application that was in for wind farms, because if you do, you establish a precedent. So you're actually being better not to approve any, because you're not going, I mean, there is a risk here about members actually being sensible and approving some applications on the basis of justification. But there's a danger if you do, you simply say to the whole of the country, bring more, because you've agreed one, so there's now no restriction or constraint on what else you do.
Ian?
Just wondering if we're in session yet, Chairman. Yep, I would move the recommendations, Chairman.
Jane?
Well, I think there's a concern about the lighting issue, and people are raising concerns actually about the whole process. I don't think we should just be saying yes without. I'm afraid. I think there are difficulties with this, but I mean, I'm sure we can find a form of wording to say that yes, we do object. There's no reason that you don't at all. I think people are now beginning to wring their hands and wishing that they hadn't done what they did last year, and I don't blame them. But there is certainly an issue that if these are very high at 152, that was not what we expected to have happen. I mean, these are 528 feet high. These are enormous, with lights in the middle of them.
Jim?
So you can see them, that's right. So
Chair,
I'm
sorry. I believe 5 of these turbines are 176 metres high. By far the biggest turbines ever to come in front of this committee.
Alistair.
If we're going to raise no objection, Chair, can I suggest that we make it clear that, well, you know, subject to the proviso that they will remove turbine 12? I mean, I think, you know, I do share colleagues' concerns, particularly as expressed by the Vice Chair, but at the end of the day, I think we've got to accept the reality, probably, of the situation. But, you know, Andrew has said in his report, he's pointed out that it would have a mitigating effect to remove turbine 12, and I think we should link that into the decision that we take, if that decision, in fact, is not to raise any objection as recommended to them.
Stephen?
Yeah, it was just to, how do we ensure that we've captured the likes of Councillor Syme's concern about community councils actually being contacted by the developer, etc.? I know there was an action point or a note taken about that could be fed back, although how it sits with the actual decision of this committee in terms of whether or not we raise an objection. So is that a separate action, or does that go as part of our response?
Separate action, I would think. As I say, it's up to the community councils to put their objection in. As I said, we're only this is only us putting the same as what a community council could do. Davy?
Just a quickie. With all due respect to Councillor Dempster, he's been here long enough to realise that if you allow a house and a plot of land that will take 3 or 4 houses, you give permission for one, the next thing you know there's 4 there, and it's the same with turbines. I'm sure he's been here long enough to know that. Thanks, Chair.
I'm sure I don't need that reminding.
Yeah, I've got Ian put a motion forward here, and I'm sure I heard someone saying, agree with that. Agree with it. Is that right, Tom? Is there any otherwise minded?
I mean, if Alistair wishes to put no objection with the removal of turbine 12, I'm happy to second that.
Is that no contradiction in terms, though? No objection, but remove a turbine?
I feel strongly enough about this, sir, to change the wording then, and make it clear that, you know, we will accept what's being suggested. We will raise no objection to what's being suggested, subject to the proviso that they remove turbine 12.
Okay.
Right, Lucy. The order, please. Lucy.
Okay, I have a motion put forward by Councillor Crothers and seconded by Councillor...
No, it's just a straightforward motion with that amendment put into it.
Okay, so
Everybody's minded it. We can raise no objection other than the removal of, we suggest that they remove turbine 12. Ivor?
Chair, that is an objection. If you say there is a condition, that is an objection. So you either have no objection or you have an objection.
He said, raise no objection to what's being proposed, subject to the proviso that turbine 12 is removed. I don't see there any difficulty with that, you know.
No, Ivor seems to help.
Chair, if you put that in, if you don't remove turbine 12, you're objecting to the proposal. Doesn't matter how you word it, black or white, that's what it is. You're either agreeing to what's in front of us or you're not agreeing.
Right, we've got a motion and an amendment. We've got a motion to raise no objection, and we've got an amendment to go with no objection, but to remove turbine.
Well, no, with the greatest of respect, sir, it's no objection. I'm saying that, you know, we raise no objection on subject to the proviso that turbine 12 is removed. Is that competent or is it no competent, Chair?
I would suggest that the
amendment... Chair, excuse me just a second. Councillor Crothers came forward, nobody got a chance to say they wanted to support or not. He moved the recommendations. And I'm prepared to move move the recommendation as per the officer's report.
Through you, Chair, but I had it seconded by Councillor McCoskey. Is that correct? It's okay. Through your Chair, What I have here is that we have a motion put forward by Councillor Crothers, and that's seconded by Councillor McCoftry, and that's to go with the recommendation on the report, which would be raise no objection. And I have an amendment from Councillor Geddes, seconded by Councillor Drybrough, that perhaps have this that members are satisfied with the proposals. However, would request that turbine 12 is removed.
Chair.
For the voice of doubt,
easier,
Chair, raising no
objection,
objection, subject to the proviso that turbine 12 is removed. I didn't quite hear whether or not that was what Lucy said.
Okay. Okay, raise no objection, subject to turbine 12 being removed. Are members happy with that? Okay.
Be helpful if we're talking about removal if I removed my amendment.
I mean, I've heard a number of queries going around as to whether or not it's competent. Clearly, if this were a planning application, I would advise that you probably shouldn't be doing that because you have an application for the erection of 22 wind turbines before you. And if the applicant hadn't voluntarily said, well, we're willing to delete that, then really what has been applied to the Scottish Government here is the 22 wind turbines. But we're not the planning authority with this one, we're a consultee, so the shackles aren't quite on this in the same extent. It would be open to you, I would say, really basically what Councillor Geddes has said, which is the council doesn't object to this, but would wish to see turbine 12 deleted. And that's your response as a consultee. I don't think that's incompetent.
With your leave, Chair, on that basis, I'll retain my amendments if Archie's prepared to second me.
Go to the vote.
Okay, I'm just going to read the vote out just to be clear here, that the motion put forward by Councillor Crothers and seconded by Councillor McCoftry is to go with the recommendation and raise no objection. And the amendment by Councillor Geddes and seconded by Councillor Drybrough is the consultation response would be that the council does not object but would wish to see turbine 12 removed. Councillor Martin.
Amendment.
Councillor Dempster.
Amendment.
Councillor Crothers.
Motion.
Councillor Dick.
Motion.
Councillor Drybrough.
Amendment.
Councillor Ferguson.
Motion.
Councillor Geddes.
Amendment.
Councillor Hislop.
Motion.
Councillor Maitland.
Amendment.
Councillor McCoftry.
Motion.
Councillor McComb.
Amendment.
Councillor McKee.
Amendment.
Councillor Syme.
Amendment.
Councillor Thompson.
Amendment.
And I can confirm that the amendment carries, and therefore the response will be that the council does not object but would wish to see turbine 12 removed.
Thanks, Lucy. Go to the item 9 now. The Harbour Master's Office, Market Street, Stranraer, application for A, plan permission for alterations, extension and change of use of former Harbour Master's Office to Exhibition Centre and Landscaping Works, 16/1688/FUL, and B, listed building consent for alterations and extension to former Harbour Master's Office to bring about the change to use to an exhibition centre, 16/1689/LBC. We've got Billy Murray speaking to this one. Whenever you're ready, Billy.
Yes, thank you, Chair. As you say, this is an application for alterations and extension to a listed former Harbour Master's Office to form an exhibition centre. So the first application is for planning permission for these works, and the second application is for listed building consent for the alterations to the building itself and the extension. So that's the application site. The location plan, it sits at the entrance to Stranraer Harbour. Historically, it was the Harbour Master's office with associated weighbridge. That's a closer view showing the location of the site. This is a view of the building itself from the junction of King Street and Market Street. That's at the main entrance to the harbour. That's a closer view of the southern elevation, which is the principal elevation of the property. In that view, the proposed extension would be to the right on the eastern elevation. That's a similar view, but just showing the weighbridge that sits beside the office. This is the eastern elevation. This is the elevation on which the extension would be attached. The window you see in the centre there is the main alteration that there would be to the existing listed building. A doorway would be formed there so that there was access into the Harbour Master's office itself from the proposed glazed link between the extension and the building itself. This is a view showing the northern and eastern elevations. Again, the window you see on the left there is the one that would be changed to a door. This is the western elevation looking over the weighbridge. You'll note that there's a bay type window there, so that's the window where when vehicles were being weighed going in or out of the harbour, they would communicate with the harbour master or the staff inside who were carrying out the weighing operations. These are more distant views in the next few slides. This is a more distant view from the east at the Queen Street Market Street junction. This is a view across the Breastworks car park to the east of the proposed building. Similar direction showing the car park and the core path, which is identified in the report as core path 544. So that's a public walk and cycleway. That's a closer view of from the northeast. Again, the extension would be on the elevation facing you in that view. This is more distant view from the opposite direction, from the west on Agnew Crescent. And this is a view across the large car park, which is to the west of the building. A better view perhaps just showing the entrance again from the west on Agnew Crescent, showing the entrance to the harbour and the building. This is a close view of the bay window in the western elevation. You'll note in the report there is, when we're discussing the merits of a listed building consent application, there's considerable reference to the windows and the condition of the windows and the requirement to replace them and how that should be specified. The original windows installed at the time the property was built in the 1930s were these Crittall steel windows. So I've got a few closer views just showing the general condition of them. They are clearly in deteriorating condition, largely because of their location beside the sea, I suspect. They're not beyond repair, and therefore we've recommended that a condition be attached requiring essentially re-emphasising that the existing windows should be retained if possible and renovated, and if they have to be replaced, that there's a requirement that they give reasonable justification for that replacement, and the planning authority retains the option to approve what windows are used as replacements. That's again a closer view of the condition of one of the windows. These are the plans submitted with the application, so that's the location plan. A closer view and the site plan as existing, showing the building and the weighbridge. This is existing elevations and floor plan. This is the proposed site plan, showing the extension on the right in that view with the glazed link between the two buildings and the proposed public realm works fronting the building to the south. That would be the main entrance into the building from the public road, would lead through that small square that's to be formed there. Again, this is a closer view showing the floor plan of the extension. Elevations, southern and western elevations showing the building and the extension. Northern and eastern elevations. This is a three-dimensional image as proposed. Sorry, my remote's not cooperating. Yes, this is a second three-dimensional view as proposed from the other direction. And another from a similar direction. So the recommendation on both applications is to approve subject to conditions.
Members, Ian Dick.
Thanks, Chair. Can I just ask, I know it's strictly speaking not a planning issue, but I'm very well aware of the fact that the government grant for this construction is time limited. I'm just wondering, Mr. Murray, if any of the recommended decisions there involving, you know, submitting approved plans regarding the listing issues such as repairs and renovations and so on, will that in any way hold that up? I'm just concerned that at what point does the government say, yeah, that's fine, we can go ahead with the granting? Is that subject to this planning application today? Would that trigger it?
I can't comment on the financing of the project. What I can say is that the conditions in the way they've been framed should not delay commencement of the project. For example, in terms of the agreement of the external stone cladding, I've worded the condition in such a way that other construction works could commence while that was being agreed, whereas sometimes we would say that no work shall commence until such time as so. This condition just says no works in the external wall cladding shall commence. So I don't see that there's anything in terms of this recommendation that should delay the project. And indeed, at the end of the day, it's in the developer's hands to address those things as promptly as possible.
Yeah, I'm reassured. Thanks very much.
Archie.
Thanks, I mean, I don't have any problems with this actual application. It's just to make sure that when the planting is done, the proper trees are put in place. We don't want to see what's happened before. And if members are willing, just go with the recommendation.
Andy.
I'm tending to agree with Archie, but I'm just wondering if the recommendation 2 at 5.2 is actually practical, because some of the new, does that mean the rest of the windows are going to be the same as the original windows, right? Or are we going to have some metal windows for one part of it and a totally modern bit at the new part? So do we need to put that in at this moment in time is the question. Because if we don't, I'd be minded to remove that second part of it, the old 1930s steel windows, because is it practical? I think is a Billy, you know.
Billy.
Yes, it is practical, and it is a fundamental requirement that you know, that we retain the character of the original listed building. That triple small pane single glazed windows are a very important characteristic feature of that listed building. What was proposed originally on submission was that these were to be replaced. And if you refer to consultations from Historic Environment Scotland and our own conservation planner, they were strongly against the windows as originally proposed. So therefore, we can't overstress the importance of retaining these windows in the building. And Crittall themselves can still manufacture and probably still have specifications and moulds for these original windows. And just finally, briefly, there's nothing in policy or guidance to prevent you having traditional type windows in the core building, if you will, the listed building, with a modernly designed solution and specified in the extension.
Andy.
So, just to make sure we make the right decision here, Billy, I'm supportive of this, obviously, but there's a full building height window in there. You know, so unless that's got something similar to the original building, it's no in keeping with the original building. That's the point I'm trying to get at here. So I'm quite happy to go with this, but I'm just saying, is it really practical? And are they going to come back to us in 3 weeks' time or 6 weeks' time and say these aren't repairable?
Billy, I think you said it.
The condition is framed in such a way that if they find that they're not repairable, they're required to come back to us with a report, first of all, justifying why they're not repairable, which gives us an opportunity to look more closely at that. And secondly, if we accept that they are not repairable, beyond repair and must be replaced, we retain the power to agree what is put in their place, and that these replacement windows should effectively be like for like in every respect.
Members agree to go to the recommendations? I think. Yeah. Ian, do you want to come back in there?
I'm more than happy with this design. I think it's going to be a tremendous feature.
Alistair?
One very brief observation, if I may, Chair. If you go to paragraph 2.1.f, and you'll see Historic Environment Scotland's comments talk about damning something with faint praise. I'll leave it at that.
I think that was it. Go with the recommendation. Item 10, Troqueer Pumping Station, Hamilton, Starke Park, Moat Road, Dumfries. Plan application for installation of wastewater pumping station, erection of a 2.4 metre high security fencing, formation of access and associated works in landscaping, 16/1680/FUL, and Judith is speaking on this one. Are we ready, Judith?
Yes, thank you, Chair. Just moving on. Here we are. This is the application site. It's to the north of the wastewater treatment works, adjacent to the River Nith. The site includes an existing pumping station and an area of adjacent amenity land which is designated as protected open space. Parts of the application site lie within areas designated as high likelihood of coastal and river flooding. Moving on, this is the block plan as existing. The River Nith cuts across the bottom of that drawing, and the existing pumping station is adjacent to the river in the bottom centre of the application site with an outfall to the River Nith. That's the existing pumping station there, and there's an outfall here which is being retained. The existing access road comes in from West Riverside Drive down here to the pumping station, there's parking there, and down here to the wastewater treatment work. This is the block plan as proposed. There's quite a lot of information on this. It shows the existing pumping station patched in kind of orange there, which would be decommissioned. And the proposed pumping station is outlined in green here. That's the majority of it, but there's a bit here, part which has the substation, the MCC kiosk, and lay-down areas for a temporary generator and temporary something else, which I'll come to later. Fuel tank. Stop. A series of new manholes would be constructed and pipework, which would take the flow from the existing infall here round and into the pumping station here. The flow runs round and into 3 channels. Once it's in the pumping station, it goes in here in one of very shaky mouse. It's showing my shaking hand. The 3 chambers in here, which you'll see later in other drawings. Part 1 of 1.9 of my report details the reasons why the pumping station is required, the new pumping station required, but it's mainly due to upgrading of the storm screens, which is needed to meet SEPA requirements. The existing access road would be diverted with the new part running along the edge of the pumping station. It would at the moment goes down here, right down, and it's going to come in and go down there. This part here is for a temporary haul road, which is needed so that access to the wastewater treatment works is unimpeded during the construction period. and it would be reinstated after construction, and there's a condition requiring that's done. As parts of the application site lie within a designated flood area, a flood storage scheme is also proposed as part of the application. This includes reprofiling 2 areas of land which are shown at the top and the right of the site. That's this one here, and these are the banking going down to the flat areas in the centre. Moving on to the site elevations, shows elevations A and B. The elevations, the orange hatched areas, are structures relating to the existing pumping station that would be removed. The proposed pumping station would be about 3 metres above ground level, although the screw pump units and other items would be a bit higher than this. Pumping station would be constructed from reinforced concrete with safety handrails. These are the other elevations. The top elevation, the one on the top, is looking from the direction of the river, and you can see the substation, the kiosk, and the lay-down areas. Beyond that, these are the 3 screw pumps that are actually part of, the main part of the pumping station. This is a general arrangement. There are 2 plans on here. The top one is a plan of the top of the pumping station, where so it's like got grills and covers to give access in, and the bottom one shows the inside of the pumping station. So this is what I was explaining earlier. The flow comes in here and goes into one of these three screw pumps and raised up to the new level where it goes out, and then it goes round and back in to the existing system. Pumping station general sections, and these are just, they've got 2 long sections and 2 short sections. The first one's just showing the inflow, the bottom one's showing the 3 screw pumps. Oh, we're way ahead now. That one. Pumping station general sections, these are the long sections through, so the top one are the screw pumps, which raise the flow from here, up here, and then out, and this is just the flow coming in to go round here and then up to the pump. Flood storage before and after construction. This shows the left-hand side, obviously, before construction, the right-hand side after. The last response we had from SEPA confirmed that the additional flood storage proposed as part of the application is welcome but not essential, and a condition has been included removing this element of works from the scheme. The sections are to follow in section CC, which runs through the site. That one, along one of the long sections running through, that one there is probably the most significant. So this is going through with the new pumping station, the old substation is being removed. This is, sorry, the new pumping station, this is the old pumping station which would be removed and the ground reinstated. And these are the, it's not that, I haven't come out that clear, but these are areas that are excavated out in here to provide storage. It's better on that one, and that's much better on that screen. And you can see the excavated areas. This is just an additional drawing that shows the proposed access road, with really the area enclosed in the hatching is within the fence. Oh, and just to go to the report, there's a small error in the report in paragraph 4.4, halfway down. It says the footprint of the area of open space which would be lost is the area which would be enclosed by the fence and extends to approximately 1930 metres, that should be metres squared. And currently fenced, I think off should have another F, and is approximately 1,160 metres, that should also be metres squared. This is the landscaping proposals drawing. There would be a loss of some trees and bushes which are required to be removed, and the landscaping proposals include 8 alder trees along the southeastern boundary and a mix of trees and woodland planting around the new pumping station. Moving on to the photographs, this is a view south from West Riverside Drive. You can see the existing pumping station here and the road to the wastewater treatment works which comes down and along. Also the core path that runs in front of the application site, and the area in here would be the area for compensatory flood storage, with the new pumping station in this area here. This is panning round from the previous slide towards the pitches in the pavilion. In the middle of the left-hand side, you can see the access to the wastewater treatment works in the distance there, with the wastewater treatment works behind the trees. You can also see the core path in the foreground. View towards the river, location of the pumping station, where those trees are, the existing pumping station. Moving on, existing pumping station which would be removed. This is just looking along the road towards the wastewater treatment works from the existing pumping station, and the site of the new pumping station would be where the trees are on the right-hand side. This is over the riverbank, on the riverbank looking upstream, and the pumping station is behind the trees, and this is turning around looking downstream to the wastewater treatment work. It's a view northwest from the pumping station. This is just taken next to the pumping station with it on my right-hand side. The 2-storey houses are West Riverside Drive, and the sports pavilion is the red brick building on the left-hand side. And this is a view from the flood storage area northwest up to West Riverside Drive. I just included this one to show the slope up. In conclusion, the application is recommended for approval, subject to the conditions, all as detailed and discussed in the report.
Tom?
Yeah, can I thank Judith very much for presenting this. The reason I called it in... What?
You finished? Oh, you had. Tom?
Yeah, I want to thank Judith very much for presenting this, because it's been a great difficulty. But when this first came forward, it was pretty straightforward. There's no objections to SEPA whatsoever. And it went through the Common Good Committee. Then just the end of November, a report went up to the Policy Committee, where, and you saw how bad the plans were earlier on there, because you've got certain things overlaid on other things. Our Property Services folk misread it, and they came to the Policy Committee with certain recommendations. And it was a verbal report. I went to see Judith. We couldn't make head nor tail of the plans to begin with. We sat down after the new year with more detailed plans. Summed up in SEPA couldn't do the Scottish Water plans either, because they had what they called a storage area, but it was a temporary storage area, and that was to store the goods to build the new pumping station. Somebody in SEPA thought this was a temporary storage area for flood water. And therefore what they wanted to do was, all that grassed area you saw was dig down to a depth of 6 feet, virtually create a huge swimming pool. And thanks to Judith finally getting in touch with somebody in SEPA and getting them to have a look at the plans more closely, we're back to where we should be. But I think it's a salutary lesson that we make sure that those who apply for planning permission put in suitable plans, because we had our own property services folk totally misled by these plans, with somebody sitting at a desk up in Hamilton in the SEPA office, totally mesmerised by the plans. If they'd gone through, as they did at a policy committee meeting, we could end up being a laughing stock of a council with a huge, great big hole in the ground because folk couldn't read plans properly. And I think Scottish Water should be told, and told quite clearly in future, let's have simple plans that even a simpleton like me can understand. If it's creating difficulties for trained planners, architects, and folk who are supposed to know about these kind of things, then it's not acceptable. And that's why I wanted it brought before the committee. Because if it had gone forward the way it was going, it'd been an absolute travesty. But I think as it is, it's fine now. But really make sure the applicants put in proper plans, not overlaying 5 or 6 plans on top of each other.
I suggest we go with the recommendation still. Agreed. Agreed. Go to item 11 on the agenda, 6 Lovers Walk, Dumfries. Plan application for alterations including enlargement of window opening to form a door opening and installation of external stair and balustrade to rear elevation, replacement of 3 roof lights, painting front and rear doors, blocking up door, opening to rear, door opening to the rear, alterations to downpipes, alterations to patio, and erection of a 1.4 metre high fence, 17/0114/FDL. And we've got Beth Halliday on this one. Whenever you're ready, Beth.
Thank you, Chair. This application is for alterations to a dwelling house to include, I'll just go through the list. To the front of it is the replacement of 1 roof light, and to the front, the painting of the front door. And to the rear, it is for the enlargement of a window opening to form a door opening, for the installation of an external stair and balustrade, 2 roof lights, the painting of a rear door, the blocking up of a door to the rear, alterations to downpipes, alterations to the patio area, and the erection of a 1.4 metre high timber fence. So just going through it's on Lovers Walk, one of the semi-detached 2-storey dwelling houses. This is the existing and proposed block plan, just showing the Mews Lane that takes access to the rear of the properties to Lovers Walk, and then at the end to the west side of that is the usual place, eating place. These are the existing elevations, so this is just showing that to the front elevation, it's showing the roof light at the moment, and obviously the front door, and to the rear, the door to the left of it, where you can see the basement door, it would be over that where the balustrade and the external staircase would be. It shows better on this one. So you've got the 2 new roof lights to the rear as well, and the existing window being changed into a door, the new staircase balustrade, and then the repainting of the existing doors with the new timber fascias to them. Existing floor plans. And the proposed floor plans. And the fence at the rear, timber fence with a gloss black painted gate. The external stair details of the balustrade. The overview of Lovers Walk, so it's one of the properties down nearer to Academy Street. Frontage of it with the white front door. And then a view to the rear. So you can see where the basement door is, the staircase would be proposed for. And that's just looking out towards Ray Street, just to give you an overview of the small lane at the back. And again, looking towards the west and looking towards the usual place rear part. And again, the area where the patio is to be extended and the new fence and gate to be erected. That's just more of an oversight, just looking to the rear of the adjacent properties and the rear of the usual place. And again, just looking to the rear of the properties to the east. The reason this application is before you is that the applicant is a council officer directly involved in the planning process, and the application is recommended for approval for the reasons set out in the report.
Agree with the recommendations, Chair.
Great. As I have no further business, thank you for coming along today. I'll see you at the next meeting in April. Our last.